Oh, I see. Please stop all case.
Yeah. Can you start what's not now? Or to change it? We could put the information in.
Waiting, and then
Avita, can you hear me?
Yes.
All right, I'm trying to put my video on because you did not put me into a breakout room, and I can see that the other parties, or at least some parties, are present.
It says here that you're in the breakout room. That's why I'm confused.
Well, test to see if the other parties can hear me. Ms. Dill Francois is shaking her head. Her phone is on mute, but I can see that that's a confirmation that everyone else can hear me.
Yes, I can hear you.
So I'm not in a breakout room, but let's not waste any further time on it. Why don't we, if you could permit my video, because it's saying the video is not permitted because the host has disconnected me from it. You cannot start your video because the host, let's see. I'm being told I cannot start the video. Can anyone see me?
Yes, we can see you now.
Okay. All right, I can see Mr. Stevens and Mr. Francois and Mr. Snelling. A minute. All right, Avita, why don't you read the heading and we can just get us started.
Okay. Tuesday, the first day of December 2020, Court Commercial Court 2 at 9:53 before the Honorable Justice Sylvia Williams, Appellate Jurisdiction 2019, number 33, Dr. Asad Qamar versus the Bermuda Medical Council, Mr. Sam Stevens for the applicant, Ms. Shakira Dill Francois for the respondent.
Yes, good morning, everyone.
Good morning.
I can see that Ms. Snelling is also present. Ms. Snelling, you are present in what capacity?
Just a watching brief as counsel for the BMC. So okay. I will, for once, keep my mouth shut, my lady.
Okay, thank you.
My pupil is also attending. If I could introduce Ms. Gambrel Robinson. She's assisted us with the case. Again, just watching brief as well for training.
That's Ms. Gabrielle Robinson, you said?
Gambrel Robinson, yes. Thank you.
Good morning.
Yes, good morning, Ms. Robinson.
Mm-hmm.
My lady, you also see Dr. Fiona Ross and Dr. Cheryl Peekball.
I don't see them, but are they?
They are present.
Okay, let me just, I do have a scroll. Let me go through one moment. Yes, I can see we have Dr. Cheryl Peekball, yes. And we have Dr. Fiona Ross.
Yes.
And we have the appellant, Dr. Qamar.
Yes. So Dr. Peekball and Dr. Ross are members of the council.
Yes.
And Dr. Doherty, at the moment, he's with patients, but he'll be joining us as well.
Okay, thank you.
And in the room with me, I have Crown Counsel Tania Tucker and Junior Crown Counsel Janae Nesbitt.
Yeah.
And my lady, in the room with me, albeit off screen, is Mr. Marcus Simons, who is a pupil at Kerry Olson and is here in a observing capacity.
Yes, thank you. Okay, so these are open court proceedings. This is an appeal, which is regulated by the rules of the Supreme Court. The matter of Dr. Asad Qamar. We've already had the heading. I've had some directions already canvassed with the parties, so I anticipate that I will be hearing opening speeches, well, at least one opening speech from you, Mr. Stevens, this morning. I think you estimated something between 60 to 90 minutes.
I think that's right, my lady. I anticipate I will be just over an hour.
Okay. All right. Any housekeeping matters, or can we get started?
Not from our side, my lady.
Okay. Anyone else? No? Okay, good. Yes, you can start. Thank you.
Thank you. Good morning, my lady, and thank you. As you have identified, I appear on behalf of the appellant, Dr. Asad Qamar. My learned friend, Mr. Francois, appears on behalf of the respondent, the Bermuda Medical Council. This is an appeal against the decision of the respondent's Credentials Committee to reject the appellant's application to be registered as a medical practitioner in Bermuda under Section 7 of the Medical Practitioners Act 1950. Now, as the court will be aware from the material submitted, the appellant's application was rejected by the committee because, in its view, the appellant meet the statutory definition of duly eligible applicant under Section 7 of the Act, because the committee formed the view that the appellant was not of good character. Now, the relevant provisions of Section 7 are set out in paragraph 15 of my skeleton argument. My lady, I just wanted to check at the outset that you have that.
Yes, and I can also confirm for you, I have read through your skeleton argument.
Thank you. I'm grateful, my lady. So, as I said, the relevant provisions of Section 7 of the Act are set out at paragraph 15 of my skeleton. Section 7, subsection 3, the Council's consideration of an applicant for registration.
Sorry, can I just ask for everyone else to mute their own devices, because I'm having some difficulty, admittedly, Mr. Stevens, hearing you. It may be that I have some background noise myself in my office with the air conditioning, or that no one else is on mute, but let's just try this. Can you?
My lady, I find it works best if everybody apart from the speaker mutes their line, and to the extent that anybody wants to say anything, then they unmute. I find that's
yes. Thank you.
Okay.
Mm-hmm.
Can you hear me clearly, my lady?
Yes,
Just
thank you.
dive in. Thanks. I was quoting from Section 7, subsection 3, where the Council's consideration of an applicant for registration shall be conducted on behalf of the Council and in the Council's name by a Credentials Committee appointed for the purpose of the application by the Council. And that committee shall determine on behalf of the Council and in their name whether the applicant is a duly eligible applicant under the Act. And
can I just jump through this, Mrs. Stevens? The real issue is comes down to good character. Is that
that's right?
To say?
That's correct. That's
Can
right.
we just jump straight to that then?
To move on, I was just setting the scene, but I don't have to take the court through the provisions. If the court has those, that's fine.
Yes.
I was just going to say that in terms of identifying the statutory basis for the appeal, that's set out at Section 7(6) and Section 25(1) of the Act. And again, I've set out those provisions at paragraphs 2 to 7 of my skeleton argument. So again, I think the court has those, so I don't intend to take the court through those.
Yes.
In terms of the structure of my opening submissions, my lady, I'm going to start, if I may, with some general overarching points that I would invite the court to consider carefully once it steps back from the details of the case.
Yes.
I'll then move on to make some points, I think, as to the precise nature of this appeal, because on the face of the written submissions, there appears to be what may appear to be some controversy between the parties about that. And I think it's important for the court to have a very clear understanding of the precise task precise nature of the task it has in this appeal.
Mhm.
I then want to take the court through a summary of the relevant factual matrix, both with regard to the allegations that were made against the appellant in the United States, which are, for better or for worse, front and center in this appeal. And also with regard to the process of the application for registration itself, which I think bears some explaining. Now, it's not my intention to get too bogged down in the minutiae of the facts, but at the same time, I think it's important I take the court through the salient events in some detail, as the facts of the case are somewhat complex, involve matters of Florida medical and federal medical law in the US. And it's the appellant's position that once all of the facts are properly understood in context, it will become clear to the court that he is a man of good character, and that the respondent's decision proceeded on a number of clearly false premises. I'll then move on to address and analyze the meaning of good character in the context of applications for registration of medical practitioners and its application to the facts of this case. And finally, I intend, if I may, to spend a little bit of time dealing with the respondent's authorities and explaining why, on the facts at least, they are clearly distinguishable from the facts of this case. So that'll be the structure of my submissions this morning. Like I say, my lady, I anticipate taking just over an hour of the court's time. So if I may start with just some headline points, which in order to sort of set the scene for the appellant case. The court's central task in this appeal is to decide, on the basis of the evidence before it, whether the appellant is of good character. That is the only substantive issue before the court. There's no quarrel between the parties that any of the other constituent parts that make up a duly eligible applicant under the Act are either met in the appellant's case or are simply not applicable. So if the court decides, once it's heard all of the evidence, that the appellant is of good character and therefore is a duly eligible applicant under the Act, then the appropriate course is for the court to order that the respondent proceed to register him as a medical practitioner in Bermuda. Now, a very important element of the court's task is to decide for itself the question of whether unproven allegations of wrongdoing, as opposed to proven facts, should play any part in an assessment of an individual's character. For however much the respondent now may protest that the unproven allegations that were made against the appellant in the United States did not play a major role in its decision to reject the appellant's application, that claim is belied, we would respectfully submit, by the extensive quotations from the media, the lurid media coverage, which are littered throughout the respondent's written reasons for rejecting the application, the contents of the respondent's evidence in this appeal, and most recently, the contents of the respondent's skeleton argument. The reality is, my lady, that the allegations in question and the media headlines that those allegations generated heavily colored the respondent's approach to the respondent's application in what we say was an inappropriate way.
Mr. Stevens, let me just ask you, how concerned really do I need to be as to how the respondent approached it in the first instance? I think one of the points that is made by the respondent's counsel, Ms. Francois, is this is a rehearing. And so even if you can properly criticize the reasons that were given by the counsel in its decision, I'm considering this anew. And the emphasis, as I understand it, at least from the respondent's submissions, is that he was misleading in his application form in terms of the information that was provided to be registered.
Yeah.
That's really where the criticism or the focus of the criticism is factually, as I understand it. Again, I'll hear from Ms. Francois in due course,
Yes.
But that's my understanding. So my question to you is how much detail is really necessary as to how the respondent approached it in the first instance?
your lady, you're correct that the focus of the criticism now is that the appellant submitted misleading or incomplete answers on his application form. But the point I was making simply is that if one reads the decision and if one reads the respondent's evidence, it's quite clear that their whole approach to the appellant and his application was influenced in a meaningful way by the allegations and the media coverage that was generated. And in effect, they were more concerned about how that decision would, a decision to register him would be perceived in the court of public opinion than they were in giving the appellant a fair, the appellant's application a fair assessment.
Let's suppose that you're correct on that.
Sorry, my lady.
Let's suppose for a moment that you are correct on on that front. It is still open to the respondent now to argue it anew and shift the focus on other factual components of
exactly, my lady, and
the grounds.
Exactly, my lady. And a significant portion of my opening submissions will be dealing with that precise point. And I will be taking the court to the application form. I'll be taking the court to the questions asked. And in light of the facts, explaining why the answers that the appellant provided were truthful and honest answers. And that every answer he gave to any subsequent question that he was ever asked by the respondent when his application was under consideration was also honest, truthful, and fulsome. So I'll get to that point. I was just making some initial points about the context in which his application.
Background.
Yes. Yeah. But now, moving on, the appellant, dealing with the allegations, the appellant, I think, would be the first to acknowledge that the last 9 years of his life and his career have been nothing if not eventful. And the nature of the allegations that were made against him certainly generated no shortage of notoriety. But the simple fact, which I will come back to again and again in these submissions, is that none of these allegations made against him were ever proven or admitted. And more importantly, and this is something that the appellant does not think the respondent gave him sufficient credit for, the allegations were subsequently found to be entirely baseless following an extensive independent investigation by the Florida Department of Health. So the appellant's position is that none of these allegations should be on the table at all when it comes to a fair assessment of his character, as those allegations have been shown by an independent investigation by the very regulatory body which has jurisdiction over him to have no basis in reality. And the fact is, my lady, that with those discredited allegations off the table, what the court is left with in the final analysis when looking at Dr. Qamar and deciding whether he's a man of good character, the court is left with a man that has never been convicted of a crime, never been found liable for any civil wrong, has never been found guilty of any form of professional misconduct or malpractice, has never been found guilty of dishonesty in a professional or any other context, and perhaps most importantly, has never had his license to practice medicine suspended or revoked in any way whatsoever, either before or after the allegations came to light. And the court is also dealing with a man, and this is something that I alluded to in response to your questions, my lady, who provided truthful answers to every single question he was asked during the application process. And we say, my lady, that any finding that the appellant is not of good character in those circumstances would clearly be incongruous with the totality of the facts. And one final point I'd make in terms of my overarching headline points, my lady, is this. It's striking, I would submit, that none of the authorities relied on by the respondent in this appeal involve appellants against whom there existed merely unproven allegations. Instead, all of the cases cited by the respondent, in those cases, the appellants had either been convicted of a very serious crime, from murder to sexual assault, have been found guilty of very serious professional misconduct based on proven or admitted facts, and or had given answers to clear questions which were either proven or admitted to have been dishonest answers. So the appellant's case is that all of the respondents' authorities that have been submitted in this appeal can be distinguished on the facts that are before this court. I'd like, so that deals really with my headline points. I'd like to, if I can, just to move on very quickly to talk about the nature of this appeal, because you mentioned that this is an appeal by way of rehearing. And I think there's a question mark as to precisely what that means.
Yes.
Now, the basis for that is that this appeal is an appeal by way of rehearing is Order 55, Rule 3 of the Rules of the Supreme Court, and that's at
Tab 4, I have it.
Tab 4, exactly. I just thought I would deal briefly with that, if I may, just to set the context. Order 55.
Is it 55-7?
Exactly, in terms of the court's power on a rehearing. And I would direct the court's attention in particular to sub-rules 2.
Yes.
The court shall have power to receive further evidence on questions of fact, and the evidence may be given in such a manner as the court may direct. Sub-rule 3, which is the court shall have power to draw any inferences of fact which might have been drawn in the proceedings out of which the appeal arose. And the final sub-rule, which is of relevance, is sub-rule 5, which is that the court may give any judgment or decision or make any order which ought to have been given or made by the court, tribunal, or person, and make such further or other order as the case may require, or may remit the matter with the opinion of the court for rehearing and determination by it or him. So the short point based on Order 55, Rule 7, is that the court has very broad powers, very broad discretion over the conduct of this appeal and the decision it can ultimately reach. Now, the respondent makes the point in its opening submissions at paragraph 30 of the respondent's skeleton. That the fact that this appeal is by way of rehearing does not mean this court should have no regard whatsoever to the respondent's original decision to deny the appellant's application. And to be clear, the appellant does not disagree that in coming to its own view as to whether the appellant is a good character, the court should look to the original decision and take the respondent's views into account. I mean, it's not the position of the appellant that this is an appeal de novo.
Yes.
This court is not hearing this matter as an original cause of action, where all of the evidence before it is entirely fresh, and the court should really have no regard to the original decision. But by the same token, an appeal by way of rehearing is also not what might be termed a conventional appeal, such as an appeal from this court to the Bermuda Court of Appeal, where there is no fresh evidence, and the appellate court is purely concerned with whether the first instance decision was right, based on the evidence that was available at first instance. An appeal by way of rehearing is generally regarded as a hybrid of an appeal de novo and a conventional appeal, where fresh evidence can be presented, and the court is concerned with whether the first instance decision was right or should be displaced based on all of the evidence that is both old and new that is before it. And my lady,
Mr. Stevens, tell me, in terms of the relief that you seek, would you be inviting this court to remit the matter for a new credentials committee to consider the matter, or are you asking for this court to substitute a finding in place of the council's decision as through the credit committee?
Well, the starting
point
is that the court has the discretion to do both.
Yes.
We will be inviting the court to substitute its own decision as to whether or not the respondent is a good character, and therefore whether he should be deemed a duly eligible applicant. I mean, this appeal has been on foot since late last year. The appellant has been in a great deal of professional limbo since this appeal has been pending. And we would invite the court to, rather than remit the matter back to the respondent, to step into the shoes of the respondent and substitute its own decision. That's the primary relief that the appellant is seeking in this case.
So then, in reality, what that would look like is that if the court were to substitute a decision, presuming for a moment that the decision would be different than what the counsel made in the first instance, it would then, the appellant would then go through the Section 8 process of a qualifying exam. Section 8 kicks in, as I understand it, once someone has satisfied the conditions under Section 7.
My understanding that I'll defer to the respondent on that, my lady. I'm not sure I can be of assistance on that particular point. But my reading of the, and I stand to be corrected. My reading was that in terms of once the applicant has fulfilled the criteria of a duly eligible applicant, that his name is then registered, and then that medical practitioner is then free to practice in.
Well, no, under Section 8, as I read it, I would invite you to just have a look at Section 8. The applicant would then have to submit to, I think it's at least 2 practitioners by an examination committee.
My lady, if I may, if I could revisit, I'll take.
Qualifying. I mean, nothing really turns on it. It's just for me to understand what exactly you seek by way of relief and what that would look like in terms of the next step. But I don't think we need to trouble ourselves much with what would happen thereafter.
My lady, that's fine. I will take a look at Section 8 and I will seek instructions, and I can revisit that point briefly if I may. But I thought, in terms of the nature of this appeal, last night I circulated a further authority from Australia. I don't know if my lady, if that was passed on to my lady. It's PAPS and the Medical Board of South Australia, 2006 decision.
Yes.
And I circulated that mainly because it contains what I regard as a very helpful explanation of the difference between a conventional appeal, an appeal by way of rehearing, and an appeal de novo, and which is set out at paragraph 32 to 34 of the judgment. I've explained what the differences are. I mean, my explanation is on all fours with the explanation provided in this case. I just wanted
the High Court decision from Australia. What's the?
It's the Supreme Court of South Australia, PAPS and the Medical Board of South Australia, 2006 decision, and it's a useful authority on this point, my lady, because it contains a very succinct but very clear explanation of the differences between the 3 different types of appeal that we've been discussing. And that explanation is at paragraphs 32 to 34 of that judgment. It talks about an appeal strictly so called, so a conventional appeal, an appeal by way of rehearing, and then an appeal de novo. And I just thought that was...
Paragraph 32 starts, Cox J in Wigan Architects Board undertook an examination. Is that the reference?
Indeed, so exactly. And the court there is referring to other Australian judgments, but it basically sets out the discussion in a useful way. And I thought the court would find that useful in terms of understanding what this appeal is. And a further authority on the point, one should look to one of the respondents' authorities, which is GOSH and the General Medical Council, which is at tab 3 of the respondents' authorities bundle.
The respondents' authority bundle. Okay.
I could ask the court to look at paragraphs 33 and 34 of,
This is the Privy Council decision?
indeed,
Okay.
of paragraphs 33 and 34 of Lord Millett's judgment.
Yes.
Lord Millett's, and this was an appeal by a medical practitioner against the decision of the Professional Standards Committee of the General Medical Council in the UK under Section 40 of the Medical Act. And he says, at paragraph 33, practitioners have a statutory right of appeal to the board under Section 40, which does not limit or qualify the right of the appeal or the jurisdiction of the board in any respect. The board's jurisdiction is appellate, not supervisory. The appeal is by way of a rehearing in which the board is fully entitled to substitute its own decision for that of the committee. The fact that the appeal is on paper and that witnesses are not recalled makes it incumbent upon the appellant to demonstrate that some error has occurred in the proceedings before the committee or on its decision, but this is true of most appellate processes. So this is a slightly different situation than our case, my lady, because obviously in this case there is fresh evidence and
yes.
the appeal is not being heard strictly on the papers. And at paragraph 34, he goes on, it's true that the board's power of intervention may be circumscribed by the circumstances in which they are invoked, particularly in the case of appeals against sentence. But their lordships wish to emphasize, and this is important, that their powers are not as limited as may be suggested by some of the observations which have been made in the past. And if you go over, there's a reference there to the case of Evans, the General Medical Council, where in Evans, the court made it very clear that it would be very slow to overturn decisions of the Professional Conduct Committee of the GMC because it considered that the Professional Conduct Committee was much better placed than it to decide on the level of seriousness of any professional misconduct. But the critical passage for the point that I'm making, my lady, is the paragraph directly underneath the quote, where Lord Millett says, for these reasons, the board will accord an appropriate measure of respect to the judgment of the committee, whether the practitioner's failings amount to serious misconduct. And then in the next sentence, he says, but the board will not defer to the committee's judgment more than is warranted by the circumstances. The council conceded and their lordships accept that it is open to them to consider all the matters raised by Dr. Gosh in her appeal, decide whether the sanction of erasure was appropriate and necessary in the public interest or was excessive and disproportionate, and the latter event either to substitute some other penalty or to remit the case to the committee for reconsideration. And my lady, Lord Millett's statement, paragraph 34, is consistent with the approach that we are inviting the court to take in this appeal by way of rehearing.
One of the points it would seem stands in favor of your client is that the issue is good character. It's not a technical issue which requires the medical expertise of the council through the credentials committee. If we were concerned, for example, with subsection 7A as to whether or not the appellant had satisfactorily completed the course of study or examination, then it might be more appropriate in cases of that kind to remit. But really, this is just down to good character.
Exactly, my lady. That was exactly the point I was going to make, is that we're not saying that one shouldn't have regard to the respondent's original decision, but because we're not dealing with a matter of any real technicality,
yes,
what the court should feel comfortable if it forms the view that the evidence shows he is of good character of substituting its view, because the court is in just the same position to make a decision as to character as the credentials committee. So we say that the court should not simply refer to the respondent's original decision. It must consider all of the evidence raised by the appellant and decide for itself whether it agrees that the respondent, it agrees with the respondent that the appellant is not of good character or not. In other words, the court must come to its own view, I think is a long-winded way of what I was trying to say, based on all of the evidence. And of course, once all of the arguments and evidence have been ventilated, I will be inviting the court to take the view that the appellant is of good character, and it should exercise its power to substitute its own decision for that of the respondent. My lady, that deals with an appeal by way of rehearing. I'm now going to get into the facts, if I may.
Yes.
And as stated at paragraph 38 of my skeleton, the background facts of this case are set out in a large amount of detail at various parts of the evidence.
Yes.
Most particularly, I'll provide the references now just for completeness. Paragraphs 29 to 52 of the respondent's original decision, which is at pages 703 to 7.
Those references are in your skeleton argument, right?
Fine. Yes, exactly
Okay.
right. Paragraph 38 of my skeleton. All of the references to the factual background spread across the decision and the evidence are set out there so the court can find them. So to set the background, I mean, the appellant is a highly qualified and experienced interventional cardiologist.
Yeah.
He's originally from Pakistan, but he moved to the United States in 1990 to complete his master's degree at Yale University. And at Yale, he also completed his internship, residency, and fellowship training. And he became a US citizen in 2008. He's been living and working in Florida since the mid-1990s. Now, in 2009, he opened his own cardiovascular practice, the Institute of Cardiovascular Excellence, or ICE for short. And over the next 7 to 8 years, the appellant grew ICE into one of the largest cardiovascular practices in the United States. At its height, ICE had 12 cardiologists working across 7 offices in North Central Florida, employed close to 250 people, and served in excess of 24,000 patients. So it was a very, very significant business. And the appellant was not just one of the 12 cardiologists with a full-time practice, he was also the owner and manager of the business as a whole. Now, as the appellant explains in his evidence, one of the reasons ICE had so many patients was the demographic of its catchment area in North Central Florida, which has a comparatively high percentage of retirees who move from out of state to Florida to take advantage of the warm climate. And for example, the Villages, which is one of the largest, if not the largest, retirement community in the US, is located about 20 miles away from where the appellant lives. So a large percentage of ICE's patients were retirees who benefited from Medicare, or low-income individuals who were recipients of Medicaid. And in the appellant's first witness statement, which is at page 23 of the bundle, I'll just invite the court to turn that up briefly. Footnote 2 at the bottom of the page, the appellant has provided an explanation as to what Medicare and Medicaid are and who can benefit from them, just to give the court an appropriate context.
Yes, thank you.
Now, because of the profile of the patients that ICE served, ICE was one of the largest beneficiaries of Medicare reimbursements in the US. And the appellant puts that fact into context at paragraphs 21 and 22 of his first witness statement, which is at the same page my lady was looking at, page 23 and 24 of the bundle. Mm-hmm. It's true that in 2012, ICE was in fact the largest recipient of Medicare reimbursements in the US. Now, in July 2011, a disgruntled former employee of ICE, a man by the name of Dr. Robert Green, who had been fired by ICE at the end of his probation period because of a well-documented drinking problem, filed what is known as a qui tam lawsuit, which is a form of whistleblower complaint provided for under the US False Claims Act. And that lawsuit was filed against ICE. And the allegation was that ICE had been performing medically unnecessary procedures on patients and therefore submitting false claims to Medicare. And that complaint by Dr. Green prompted the opening of an investigation by a number of state and federal authorities, including the Civil Division of the US Department of Justice. While that investigation was ongoing, a second qui tam lawsuit was filed in 2014 by a lady by the name of Miss Holly Taylor, who was an employee working for ICE's third-party invoicing billing contractor. Now, the appellant's evidence, which is at paragraph 28 of his first witness statement, is that Miss Taylor and Dr. Green were romantically involved. And in any event, the allegations made by Miss Green in the second lawsuit were very similar to the allegations, Miss Roberts were very similar to the allegations made by Mr. Green, Dr. Green, in his initial complaint. Now, because the allegations concerned an alleged fraud against a federal insurance program, the False Claims Act allows the federal government to intervene in any qui tam lawsuit. And the federal government did so in December of 2014. And the lawsuits begun by Dr. Green and Ms. Roberts were consolidated into one complaint. Now, the investigation of those claims went on for a period of about 4 years, during which time all of the procedures carried out by ICE over certain treatment lines were subject to a thorough independent audit. Now, in February 2015, the appellant attended settlement discussions with the Department of Justice and the Office of the Inspector General in Washington, D.C. But ultimately, those settlement negotiations were unsuccessful because the appellant refused to settle. He strenuously denied the allegations, and he remained adamant that neither he nor ICE had done anything wrong. One month later, in March 2015, after he had refused to settle the claims with the Department of Justice, ICE's Medicare and Medicaid privileges were suspended by the authorities. And this inevitably caused major financial problems for ICE's business.
That's a 3-year revocation of the. Are you looking at paragraph 40?
That came slightly later. There was an initial suspension, okay. and then it was subsequently confirmed that that's by the Center for Medicare and Medicaid Services in April 2015. That ICE's Medicare privileges were being revoked for 3 years.
I see.
And under Florida law, a revocation of Medicare privileges has an automatic knock-on effect on Medicaid privileges at a state level. And in June 2015, the Florida Agency for Healthcare Administration banned ICE's participation in Medicaid for a period of 20 years. Again, that's set out in Dr. Qamar's statement. And as was his right, the appellant appealed against the Medicare and Medicaid revocations. Now, fast forward to June 2016, the appellant ultimately agreed to enter into a settlement agreement with the federal government concerning the complaints of Dr. Green and Ms. Roberts. And the appellant's evidence concerning his having sworn blind that he was never going to settle and he was going to fight these allegations all the way to a trial. The appellant eventually decided to settle the case, and his motivations to settle the case are set out at paragraphs 49 to 62 of his first witness statement, which are at pages
29.
But yeah, 49 to 62 of his first witness statement
Oh, I see.
which is at pages 29 to 31 of the bundle. In short, the appellant explains in those paragraphs that he had been brought to his knees financially by the strain on his business caused by the Medicare and Medicaid bans, and also the very significant amount of money, the millions of dollars that he was being required to spend on lawyers' fees in order to defend himself against these allegations.
So it's financially and commercially motivated
Indeed.
without any admissions.
Exactly right. Yeah. And paragraph 50, we'd say paragraph 54 of the appellant's first witness statement is important in this regard, but as my lady has just mentioned, because it recounts the advice from his lawyers that settlement was the most pragmatic way to protect his business and his family. And importantly, it would cost him millions of dollars in any event if he didn't want to settle and he wanted to take the matter all the way to trial, because not only would he have to pay for lawyers, there would be experts, it would be a major expense, and it would go on for a considerable amount of time. If I could just quote from paragraph 55 of his witness statement, where the appellant says, "I agonized over the decision for a long time, but in all the circumstances and after discussing the matter with my family, I made a decision to settle. As explained by Mr. Mabry, who is the appellant's healthcare lawyer, the decision to settle was made for purely practical commercial reasons and not because I accepted that I was in the wrong." And as my lady has identified, the settlement agreement entered into in June 2016 was on a no admissions basis. Mm-hmm. So none of the allegations contained in the lawsuits were ever admitted or proven. And the appellant's evidence is that he would never have agreed to the settlement if he'd been required to admit liability. And that's the statement he makes at paragraph 57 of his first witness statement, which is at page 30 of the bundle. Now, and I referred in my skeleton, my lady, at paragraph 45 to the Department of Justice's press release concerning the settlement, which is at page 55 of the bundle, 54 and 55. Now, if one looks at that press release, the headline is, "Florida cardiologists in his practice pay millions and agree to 3 years of exclusion to resolve alleged false billings and necessary procedures and legal kickbacks." Rather lurid headline. And then on page 55, the top paragraph sets out the context for the claims and the settlement, where it says the allegations resolved today by today's settlement was originally raised in 2 lawsuits filed in a Quaid Tam or whistleblower provisions of the False Claims Act.
Sorry, where are you reading from now?
Sorry, top of page 55.
Oh, I see.
Provisions of the False Claims Act, which permit private parties to sue on behalf of the government when they discover evidence that defendants have submitted false claims for government funds and to receive a share of any recovery. And if one goes down to the final sentence of the top paragraph, it seems that Dr. Green and Ms. Taylor received a total of just over $1.3 million as their share of the settlement. And the appellant has some comments to make as to the complainant's possible motivations for the allegations that were made against him. But the most important point that arises from this press release, my lady, is the final sentence of the release, which is conveniently buried, which says that the claims asserted by the government are allegations only, and there has been no determination of liability. So, now as part of the June 2016 settlement, the appellant at this point, the appellant voluntarily agreed to be excluded from Medicare for 3 years. And therefore his appeal, which he'd launched against that revocation of his Medicare privileges in April 2015, the year before, was also settled. And this left the appellant's subsisting appeal against his 20-year Medicaid ban. And in that instance, the settlement was reached with the state authorities in July of 2017. And again, Dr. Qamar voluntarily agreed to be excluded from Medicaid for the same amount of time as his exclusion from Medicare, which is a period of three years. And again, that settlement was entered into on a no admissions basis. Now, under Florida law, the appellant's voluntary exclusion from Medicare and Medicaid under those two settlement agreements had unavoidable consequences at a state level, because any licensed physician in the state of Florida who is excluded from Medicare and Medicaid and who has not been re-enrolled is subject to automatic sanction by the automatic administrative sanction by the Florida Department of Health. So the important point is that even though the settlements with the Department of Justice and the state authorities were on a no admissions basis, because the appellant had agreed under the terms of those settlements to be excluded from Medicare and Medicaid, an administrative sanction by the Florida Department of Health was an automatic consequence, or was an automatic consequence of that. Now, the administrative complaint was filed by the Florida Department of Health against the appellant on the 24th of October 2017. And that complaint can be found at pages 399 to 403 of the bundle.
Yes.
It's a very short complaint, and it basically just sets out the factual background as to the appellant's exclusion from Medicare and Medicaid. And the administrative complaint was ultimately settled by way of a settlement agreement dated the 10th of October 2018, so just under a year later. And that settlement agreement, my lady, is at pages 390 to 398 of the bundle. Now, under the terms of that settlement agreement, the appellant agreed to pay an administrative fine of $5,000. And that's at paragraph 2 on page 2 of the settlement agreement. Costs of $2,134 and undertakes certain continuing education courses.
Sorry, Mr. Stevens, I noted that you said the settlement agreement was pages 319 to 398.
Sorry, apologies, my lady. It's 390.
390.
398.
Thank you.
So he had to pay a fine of $5,000. He paid costs of just over $2,000. He agreed to undertake some risk management training, and the settlement agreement also records on its face that a letter of concern, which is a kind of mild rebuke from the Florida Department of Health, was going to be entered on against the appellant's medical license. But the evidence shows, in fact, that no letter of concern was ever placed on the file. And this is dealt with, this fact is dealt with in the witness statement of Mr. Tracy Mabry, the appellant's healthcare lawyer, at paragraph 22 of his witness statement, which is at page, for reference, 276 of the bundle. And also...
Sorry, Mr. Stevens, I'm just quite curious, looking at page 391 of the hearing bundle.
Yeah.
Paragraph 3 of the settlement agreement: for purposes of these proceedings, respondent neither admits nor denies the allegations of fact contained in the administrative complaint. Can you just elaborate a little bit further for me on how I should treat the fact that he's neither denied it nor admitted it? Is it really
Well,
something to ignore completely, or?
I don't know. I don't think much turns on it, my lady. I mean, there was a complaint made, and the complaint made was that he'd been excluded from Medicare and Medicaid, and that under Florida law, under the relevant statute under Florida law, there was automatically sanctions had to be imposed by the Florida Department of Health. I think what has happened here is that both parties have just constructively and commercially agreed to sort of compromise their respective positions. So there is no admission that he was in breach of those relevant statutes, but he's agreed to certain stipulated steps being taken in relation to both payment of money and also in relation to undertaking some minor.
I mean, does it not open up for the argument that whilst you turn to this document to suggest that he has never admitted any of the allegations against him, equally, one could turn to this document to say that they were neither denied or admitted.
Yes.
And so therefore, it may be open since the overriding test is really about good character. It's still open to the medical council or the credentials committee to make of it what they will, because there has been neither, whether it's in the affirmative or the negative, a disposition of it. This is just simply a commercial settlement.
Absolutely, and the fact of the commercial settlement is there. It's not. It can't be disputed, and more importantly, despite what the respondent may say, the fact of the settlement was disclosed by the appellant. Now, the fact of the settlement was not disclosed when the appellant signed the application form, and I will come on to the reasons for that in a moment. But the fact of the settlement was disclosed when the respondent came back and asked further questions, had conducted due diligence into the appellant's application, at which point the terms of the settlement agreement, which are private, were disclosed to the respondent, and a full explanation as to the factual background was provided.
Yes.
I understand the respondent's central complaint to be that the fact that the appellant did not disclose the terms of the settlement agreement when at the time he signed the application form gave them cause for concern. In our case, of course, is that while his application was still pending, he disclosed this settlement agreement and he explained the background. And the fact that he's disclosed this information is now effectively being held against him. Because what the respondent is saying is, well, we know you've disclosed it, but you should have disclosed it when you signed your form. And the fact that you're disclosing it now means that you've not been transparent. The appellant takes a different view of that and says that he viewed the application as part of a process, and at every single occasion when he was asked questions by the respondent, he came back with documentation and fulsome answers to all of those questions. But those are submissions I intend to make when we deal with the application form itself. But I hope that deals in part with your question. Now, again, this goes to, in terms of timing, this is important. So if one looks at the settlement agreement on page 5, which is at 394 of the bundle, and it's the paragraph 2 right at the bottom of page 394, which talks about this settlement agreement having no force or effect until final order. It's expressly understood that this agreement is subject to the approval of the board and the department, but the Florida Board of Medicine. In this regard, the foregoing paragraphs, and only the foregoing paragraphs, shall have no force and effect unless the board enters a final order incorporating the terms of this agreement. Now, the final order, this is important because the final order was not entered until the 22nd of February, 2019. So there was a gap of 4 months between the signing, the execution of the settlement agreement between the parties and the final order of the Florida Department of Health. And the final order, my lady, is at pages 387 to 389 of the bundle. Sorry, it appears that we have to go, even though we're proceeding chronologically, the way the bundle's been arranged is that we're actually going back. But anyway, it's 387 to 389 is where the final order of the Department of Health is contained. And it effectively memorializes the terms of the settlement agreement, which had been signed 4 months earlier. Now, I will come on to this, my lady, but in the context of the appellant's answer to question 3 on the application form, which is an answer that the respondent takes significant issue with, the reason for this 4-month delay is factually important. Because during this time, the appellant and his lawyers were in the process of formally seeking a waiver to his exclusion from Medicare and Medicaid through a waiver process available from the Federal Office of the Inspector General in the United States. Now this waiver process is explained at various different parts of the evidence. And I can give you the references, my lady, if that would be helpful. Paragraph 8 of Dr. Qamar's second witness statement, which is at page 282 of the bundle. And also paragraph 10 of, I'm going to take you to a letter in a moment, my lady, so I'm just giving you these other references for now, but paragraph 10 of Mr. Mabry's witness statement, which is at page 274.
Okay, you give me a lot of page references. Are these just for me to note them or for me to turn to the pages?
If you could just note those references for now, I'm going to take you to a letter from Mr. Mabry, which I'll ask you to look at.
Okay.
These are just
So
other,
I'm just simply going to note page
Yeah.
282, which is the second
second witness
witness
statement.
statement of the appellant.
It's paragraph 8.
Okay.
And
And then,
paragraph 10 of Mr. Mabry's witness statement, which is at page 274.
274. Okay.
Okay. But if I could ask the court, in terms of explaining this process in better context, if I could ask the court to turn to Mr. Mabry's letter of the 3rd of January 2018,
Which is where?
that starts at page 74 of the bundle.
74. Okay.
I'm sorry for jumping around, my lady, but
That's fine. I just, if they're just for me to keep my finger,
indeed,
at least one of them might.
a bit of
I'd
jumping.
like to know. Yes.
Try to keep that to a minimum. This is a letter from Mr. Mabry dated the 3rd of January 2018. It's a very long letter. And the part dealing with the waiver process starts at page 90, bundle reference 94. Which under the heading 6, support of the waiver of Dr. Qamar's federal healthcare program exclusion. And the second sentence of that paragraph, Mr. Mabry says, notwithstanding those terms, as in the terms of his exclusion from Medicare and Medicaid, with regard to Dr. Qamar's Medicare and Quitam settlement resulting in his voluntary exclusion from federal healthcare programs, the OIG has a process whereby, upon request initiated by a federal healthcare program administrator, a waiver may be granted to allow Dr. Qamar's resumption of participation in the Medicare and Medicaid programs. So the reason, and this is covered in the evidence that the references that I gave you earlier. Mr. Mabry's letter then goes on to, under paragraph 6, to deal with, in great detail, with the very significant efforts that were being undertaken by both him and Dr. Qamar to secure a waiver from the appellant's exclusion from health, from Medicare and Medicaid, including the submission of character affidavits and letters of support by patients, staff members, and politicians. And this was ongoing in the period between the signing of the settlement agreement and the entry of the final order in February 2019. And the important point to note is that in the event that the waiver was obtained, no administrative sanction would have been entered against the appellant by the Florida Department of Health because his Medicare and Medicaid privileges would have been restored via the waiver. So the key point, and it's one I'll revisit later, is that in contrast to the position that the respondent is taking, the appellant did not know when he signed the application form and he answered question 3 that he was going to be subject to future disciplinary action under the terms of the settlement agreement, because it was entirely possible at that point, at the time that he signed the settlement agreement, signed the application form, that a waiver would be secured and that there would be no administrative sanction entered against his record. So I will revisit when we get to the application form. I'll explain that point in the context of his specific answer and the question that was asked. But the final and probably most critical piece of evidence we say in the factual matrix is the independent investigation by the Florida Department of Health into the allegations contained in the qui tam lawsuits. This is dealt with at paragraphs 49 to 51 of my skeleton. Now, following on from the lawsuits, the Florida Department of Health opened up a separate investigation of its own into the allegations that were the source of the federal government's complaint. Mm-hmm. Now, the investigation was conducted by what's known as the probable cause panel of the Florida Department of Health, which is effectively like a investigatory and prosecutorial service run or arm of the Florida Department of Health. And now that investigation began in October of 2017. And I would refer the court to the Florida Department of Health letter dated the 16th of October, which is at page 375 of the bundle. And the court can look at it if it wants. It's effectively a letter to ICE and the appellant notifying him that an investigation into the federal government's complaints was going to be commenced. Now, this investigation by the probable cause panel lasted for more than 10 months. And it's important to note that the probable cause panel had access to all of the same paperwork that the Department of Justice had and interviewed all of the same witnesses that the Department of Justice interviewed. Now, on the 22nd of August, 2018, so 10 months later, the Florida Department of Health wrote to the appellant confirming that the probable cause panel had found no probable cause and had recommended that the investigation be closed. And the letter confirming that no probable cause had been found is at bundle reference 384. And it's a letter dated the 22nd of August, 2018, addressed to Mr. Mabry, the appellant's attorney. And so what does that mean? I think it's important for the court to understand what that means. If I could ask the court to turn to page 486 of the bundle.
Yes.
This is the homepage of the Florida Department of Health's in-house prosecution service. And if one, you see it's headed prosecution services. And if one looks halfway down the page to a heading in bold called Probable Cause Panel, PCP. Do you have that, my lady?
Yes, I see it. Yes.
It says the PCP is a panel of 2 or 3 board members usually one or two licensed healthcare professionals and a consumer member. And if one looks underneath that, you see it says a quick guide to probable cause panels. And the first bullet point is the key one for our purposes. It's a closing order. Now, you'll recall that the letter to Mr. Mabry that I showed you earlier stated that the probable cause panel had recommended that the file be closed. So a closing order is only recommended by the probable cause panel if the investigation and or the expert opinion does not support the allegations.
At what threshold? What's the test? What's the threshold that they're operating on? Is it probable cause?
Indeed, my lady. Yes, exactly right. So
is that a high threshold?
I wouldn't pretend to be an expert in Florida medical law. I mean, Mr. Mabry would be in a better position to speak to the standard, the evidential standard in that case. But one would think in circumstances where probable cause panel is investigating serious, allegations of serious misconduct, the panel takes a rigorous and robust approach to the evidence
as to whether or not a prosecution would be recommended.
Exactly, and
it would seem that would be a pretty high threshold if you're talking about criminal prosecution.
My lady, correct. And in this case,
now tell me something. If we put aside the complaints with respect to disclosure on the application, was it open to the counsel in Bermuda to look beyond whether or not there was probable cause for prosecution to make their own determination on the evidence that was available as to whether or not he meets the criteria for good character, which it would quite likely be a different threshold, wouldn't it?
Indeed, my lady. And all we're saying on that is that, as we've said before, we think, the nature of the allegations made against the appellant generated a significant amount of public notoriety, and they are, allegations that effectively dragged his reputation and the appearance of his character through the mud for the best part of 4 or 5 years. And all we are saying is that certainly it's the appellant's position that following a 10-month investigation by the probable cause panel of the Florida Department of Health, it was found that the allegations made against him were not supported by the facts. And that, in other words, there's really no other way to look at that.
It could not substantiate a criminal prosecution in their view.
Absolutely. Well, I mean, so, okay, what one could say that I think I think the court should be careful not to fall into the trap of saying, well, there are allegations made and they couldn't be proven, but somehow there should still be an element of stigma attached to the appellant.
Well, no, let's suppose for a moment that I accept your submissions in criticism of any reliance on the stigma effect. The argument is still open to the respondent to make that the counsel is not bound by the findings of the Florida probable cause panel, or however they're termed, because they are quite narrowly considering, or they're considering a narrow question as to whether or not the evidence would support a prosecution. Would that, for example, have barred any civil suits?
Again, that's a question.
Do we know? I mean, okay, so that's that, and obviously we don't have any expert evidence on matters of Florida law, but you're not able to obviously say, therefore, that their findings would have barred any other civil suit. The most that we can say is that there was a finding that the evidence did not support a criminal prosecution.
That's right, my lady, but it's also important to bear in mind who is looking at this material. I mean, it's being looked at by a panel of Dr. Qamar's, of the appellant's peers. I mean, you'll note that the PCP is made up of at least one, sometimes two medical practitioners who look at all the evidence.
Yes.
has to remember that the allegation in this case against Dr. Qamar was that he and his fellow cardiologists were performing on a wide-scale basis medically unnecessary medical procedures in order to defraud the federal government.
Mhm.
In order to decide that question, one has to look at whether the technical question as to whether or not the procedures were medically unnecessary. Those are the questions that the probable cause panel would have examined as part of its assessment of whether or not the allegations were supported by the facts.
The credentials committee is made up of medical practitioners also?
Absolutely, but I accept that. But they were assessing purely the question of the appellant's character. They weren't looking at the specific cases that were said to be performed unnecessarily and forming a clinical view as to whether that was true or false.
I see.
But I mean, the court may take a different view of this. The appellant's view of the findings of the probable cause committee, the probable cause panel rather, is that it exonerated him. And the appellant is of the view that he does not think that the respondent gave the findings of the probable cause panel sufficient credit when it was considering its application. And in keeping with that, the court should note that there's actually not a single mention of the probable cause panel's findings of no probable.
In the decision taken by the counsel.
Very brief mention of it in the decision, but there is no mention of it in any of the evidence that the respondent has submitted in this appeal.
I see.
So no mention of it at all in the respondent's skeleton either. So, the respondent has seen fit to allude to and quote extensively from the contents of Department of Justice press releases and media articles concerning the allegations made, but for the large part has conveniently ignored the findings of an independent investigation by a medical body with jurisdiction over the appellant, which concluded that the allegations were unsupported by the facts. We simply urge the court to take this critical evidence into account when it's considering the question.
I should be very persuaded by it.
Thank you, my lady. If I'm conscious of the time, I have a fair bit to get through still. Are we looking to have any form of short?
Well, I mean, if this is a convenient time for a break, that would be helpful. But let me have some idea from you as to how much longer you expect that you will be.
My lady, I suspect I will be another 30 minutes.
Okay. All right. Well, on my clock, let me see if I can get the court associate in view. We had some difficulty placing me in a breakout room before. It may very well be that I will have to leave the meeting and then rejoin it. If the court associate, I can see that, Ms. O'Connor, can you take off or can you unmute your audio? Okay. Oh, I see. It's Ms. Asad. All right. Can you please attempt to put me in a breakout room? If you are unable, then I will leave the meeting and have to rejoin at 11:30.
We should be able to do that.
Okay, let's see.
11:30, my lady, did you say?
Yes, 11:30 will break too. Thank you.
Okay, great. Thank you very much.
Should find the breakout room.
She's waiting. What else is in here?
Okay, can everyone hear me?
Yes, my lady.
All right, it looks like everyone else's audio is on mute. So there's no need for reply. It seems pretty obvious we are reconnected. Thank you, I appreciate the head nods. Yes, Mr. Stevens.
My lady, thank you. Before the break, we were talking about the probable cause panel and the standard that the probable cause panel applies.
Yes.
Allegations that are made against medical practitioners in Florida. My lady, I've taken some very short, slightly rushed instructions during the break, and I've been informed that the probable cause panel investigates all allegations of misconduct made against medical practitioners in the state of Florida, and it decides, based on the evidence, whether to refer those matters for criminal complaint or a civil complaint or an administrative complaint. So it's not purely concerned with whether or not a criminal act has been it determines whether there is probable cause to believe that the physician has violated any Florida statutes or rules and whether or not disciplinary action is warranted. Now, my lady, I'm conscious that there's no evidence before you on this point, and I don't want to just make it a matter of submission. What we can do, if my lady would like something definitive and is exercised by that point, we can.
I think it depends on the position taken by Mr. Francois. You may wish to have some dialogue with her during maybe the lunch break as to whether or not that's going to be an issue.
Sure.
And what really turns on it.
Indeed. If evidence needs to be before the court, and with the leave of the court, we could submit a very short witness statement overnight, needing evidence to make it. But anyway, I will move on from that. So I was dealing with the facts, and I've dealt with the facts relevant to the allegations that were made against him and the investigations that were subsequently undertaken. I'll now move on to deal with the central issue, the central complaint of the respondent, which is the process of the application itself and allegations that the appellant was less than transparent. And the respondent's case is sort of Neatly encapsulated in paragraph 4 of its skeleton argument, where it says that the appellant's application was rejected because of a lack of transparency and integrity when he filled out and personally signed the respondent's application form for initial registration as a medical practitioner, and his dishonest conduct thereafter. So that's the points I'm going to deal with now. In my written argument, I deal with that charge at paragraphs 52 to 63. And all of the relevant references to the evidence are contained in those paragraphs, my lady, so I don't intend to do those. But so I think in order to orientate ourselves, I think it would be good to go to the application form.
Yes.
And so if my lady could turn to page 639,
Yes.
of the bundle, which is a covering letter from the appellant's prospective employer, Bermuda Medical Specialties Group, dated the 29th of November 2018. And you'll see in the second paragraph of that letter, the BMSG state that Dr. Qamar has 19 years of experience in the field of internal medicine and cardiology, and the residents of Bermuda will be well served to have a physician of his caliber available on the island. If one turns over the page, on pages 640 and 641, you'll see the application form. Now, the date on that application form on the second page is the 19th of October. Now, but for some reason, for which the appellant actually, given the passage of time, now cannot recall, he actually filled the application form out twice. So he filled it out once on the 19th of October, 2018, but if one turns over the page, there is another copy of the application form on pages 642 and 643 of the bundle.
28th of November, 2018.
Indeed. And like I said, the appellant doesn't recall why he filled that application form in twice, but nothing really turns on that. So we don't have to dwell on the point. I will focus on the latest application form, which is the one dated the 28th of November. Mm-hmm. Now, my lady, I would start by saying at the outset that if one looks at this form as somebody who's not familiar with the process, the form is impressive in its brevity. It's 2 pages. It has 7 short form sections on it, and a section 8, which is effectively a signature block and a statement of truth. And there are 2 short paragraphs of directions to any applicant who who's filling out this form. The first is at the top of the first page under the main heading. And the second is the short sentence of directions, 2 sentences of directions under section 7, which is the screening questions. Now, that's it. The respondent has, to our knowledge, not published any other separate detailed guidance for any applicants as to how this form should be completed and what information should be included. All any applicant has to go on when filling out this form is what is written on the form itself. And that's an important point. Now, the focus of our attention in this appeal is section 7 of this form, and in particular, the controversy surrounding the appellant's answers to screening questions 3 and 4. But if I might start with the short directions at the top of section 7, it says, the form says, answer the following questions by placing a tick in the appropriate box. And those boxes are either the yes or no. And then the directions go on to say, if you answer yes to questions 2 to 6, please provide complete details on a separate sheet of paper and attach to this form, sign and date below. So that any applicant filling out this form is directed to provide further information, complete details in the event of a yes answer.
Well, I mean, the respondent, no doubt, would direct my attention to the very first paragraph in the application form, where it reads, if more space is needed to fully answer questions, attach additional sheets with typed responses.
Indeed.
So I would anticipate that what the respondent is going to argue is that it was very clear on the face of the form that full responses were invited, as opposed to just cryptic yes or no questions, notwithstanding that you have a yes or no column for these questions under section 7.
My lady, I accept that is what the form says, and the appellant accepts that point. I mean, the point in response to that is that, you know, full answers are required, may be required in circumstances where there is a need to provide full answers. If the answer that is, if the question that is asked, and a straightforward, plain reading of those words demands a simple response, then any applicant filling out this form is entitled to provide that simple response. And I will explain why in these circumstances the appellant's approach to this form was perfectly acceptable and appropriate. So the question 3, which is, has any disciplinary action been taken against you by any medical authority? And the appellant ticked the no box. And my lady, this was a truthful answer to that question.
The question is, was it a full answer?
My lady, yes. Because the question asks, has any disciplinary action been taken against you by any medical authority? And as at the 28th of November, that was a truthful answer. And I'll go on to talk about the context in a moment. But as a simple matter of fact, that is a truthful answer. The date of the form was the 28th of November. The court will recall that although the appellant had entered into an agreement, settlement agreement with the Florida Department of Health to settle the administrative complaint concerning his failure to re-enroll in Medicare and Medicaid on the 10th of September.
It was a true, let's accept for a moment that it was a true response. The question is, was it a full response? Does it give the full background? Does it give the full picture? I mean, isn't the point of the direction, which is stated twice on this form, to attach additional sheets with type responses where one is expected to fully respond, fully answer questions? It's not a question. The issue then becomes not as to whether or not the answer is technically truthful or factually truthful, but whether or not it is complete. Does it provide the full picture?
My lady, I think that as at the 28th of November 2018, the respondent's answer of no does provide the full picture, and also one has to look at the directions at the top of section 7, which is after all the section that the appellant was filling,
Yes.
with an express direction that an applicant is to provide complete details in the event of a yes answer.
So in all circumstances, if the answer is yes, you should provide further response.
Indeed.
Otherwise, as read with the direction that applies to the full form, you should, if more space is needed to fully answer the question, attach additional sheets with typed responses.
Indeed, my lady. But as you identified, the respondent concedes that the appellant's answer to question 3 was correct. Now, they say it's technically correct. Technically true, I think, is the phrase that is used.
Let's say that it's just factually correct. There's no qualification needed. Let's just assume or presume just for a moment that there is no issue and there is no contention as to whether or not his response was truthful. I would be more interested to hear submissions at some point, if not now, as to whether or not a different test is required for whether or not it is complete and full.
My lady, the appellant's position, our position is that, and I've picked up on this point in my written skeleton,
Mm-hmm.
that, any applicant filling out this form is not in a position to second guess what information the respondent may or may not require as part of the application process. It can only proceed as specifically directed on the form. Mm-hmm. And in this case, if the respondent wanted its applicants, when filling out section 7, to caveat or provide further information in relation to answers of yes or no, then it should have said so on the face of the form. Mm-hmm. The fact is that the respondent has chosen specifically to direct applicants to provide further answers in the event of yes answers, not of no answers. Now, that may be a fault of the drafter of this form, but when one is dealing with applicants from countries from overseas who are not familiar with the application process in Bermuda and have only the contents of this application form to go on.
Professional persons nonetheless.
Professional persons nonetheless, absolutely. It's our case that they can only proceed as directed. We say that in the circuit, given the very straightforward nature of the question that was asked and the fact that yes or no answers were asked for, and that further information was required only in circumstances where an answer of yes was given to any of questions 2 and 6, mm-hmm. the applicant was entitled to give a truthful answer, which is precisely what he did. Mm-hmm. Now, we'll come on to this point, but this is not a case that involves the applicant giving. So first of all, the starting point is that the answer that he gave to question 3 was a truthful answer. The second point is that this is not a case where the respondent actively concealed the fact of the settlement agreement throughout the time that his application was pending. As I made a point earlier in my submissions, he disclosed the settlement agreement, actively disclosed the settlement agreement to the respondent when the respondent asked him questions in relation to the investigations that were made into the allegations and all of the subsequent fallout. He didn't hide anything. He may not have provided that information at the point that he signed this form, but the point is he did provide that information when his application was still before the respondent. So,
Stephen, let me just ask you, nothing significant may turn on this, but I can't help but to notice question 8 under section 7 is filled out differently when you look at the two forms. So the response on the 19th of October application form is yes to the question as to whether or not do you have malpractice insurance or are you a member of a medical protection society. But he's responded no on the 28th of November 2018. Is that something that should take my attention at all, or is that anything that you want to comment on?
My lady, this is the first, thank you for pointing that out. It's the first time that I've seen that. I have no instructions as to why the answer was different. The respondent has obviously not made a case on the answer to question 8. I can, if so required, seek instructions during the lunch break, and I can provide an answer to that. It's a very short, factual answer to that question. But in relation, just to summarize, in relation to question 3, there are 2 points. The form does not direct applicants to provide further details in the event of no answers. So the appellant proceeded specifically as directed. And when he signed the application forms, the the appellant and his lawyers, and this is important to remember from the facts, were heavily engaged in the process of seeking a waiver of his exclusion from Medicare and Medicaid, which, if granted, would have meant no administrative sanctions being imposed by the Florida Department of Health. So the respondent takes the position that when the appellant signed this form, he knew that an administrative sanction was imminently going to be entered against his medical license. And that is factually incorrect. Mm-hmm. As at the time that he signed,
he was waiting for the waiver. He had already applied for the waiver.
Indeed, and if the waiver had been granted, the administrative sanction that was entered on his license in February of 2020, they would not have been entered. So he gave a truthful answer to the question. And as to the state of his knowledge at the time that he signed this form, the state of his knowledge was that he didn't know one way or another whether or not he was going to be administratively sanctioned.
Okay. And let me ask you another question, which may very well just be a photocopying glitch. Yeah. But I noticed that on page 643 of the hearing bundle, there's a section 6.
Yes.
Which applies to the 20th of November form. And that section 6 doesn't appear on the earlier application form of the 19th of October.
Elaine, I have to say that you're extremely eagle-eyed. I noticed that discrepancy as well, which is why I thought it more prudent to focus on the later form, because I suspect the later form is the complete form. And as to why section 6 is missing from the October form, I don't know, but I presume it's a photocopy.
So we would probably be more interested in the more recent 28th of November application form.
Indeed, okay. And it was his latest. It was the latest one. So I think So that's all I have to say about question 3. In relation to question 4, the question reads, have you had privileges denied, revoked, or restricted in a hospital or other healthcare facility? Now, the appellant, as my lady will see, the appellant answered no. Mm-hmm. And again, this was a truthful answer to the question. It is a fact that the appellant never had any privileges denied, revoked, or restricted in a hospital or other healthcare facility. And what is more, the respondent accepts this. It's at paragraph 34 of Dr. Ross's witness statement, which is at page 678. I would ask the court to turn that paragraph up, but also to sort of stay on the form. If you
yes. I'm going to page 678.
678. and it's paragraph 34 of Dr. Ross's evidence.
Mhm.
Says, as to question 4 on the application form, namely whether Dr. Qamar has ever had privilege denied, revoked, or restricted in a hospital or other healthcare facility, the appellant answered no, and nothing else was disclosed by him on the form. And this is the critical bit. While someone being pedantic and sticking to the strict letter of the application might agree this answer was technically true, in that the appellant did not have privileges restricted or in respect of a specific hospital or other place facility. The committee, in its professional judgment, believes that an honest and transparent doctor of good character would have disclosed that he had been terminated from all federal healthcare programs. But with respect, my lady, that's not what the question asks. And it's submitted that the appellant's reading of question 4 is not pedantic. The question is very simply and clearly worded, and the appellant answered it truthfully. And again, as I said to you before, it's not for applicants when filling out this form to second guess what information the respondent may or may not require when answering the screening questions. All an applicant can do is answer the question asked and to answer it honestly. And that is what the appellant did. Now, if in terms of question 4, if what the respondent really intends by this question is to ask applicants whether or not they've ever had any privileges denied, revoked, or restricted in their career, for example, as a medical practitioner, then it's incumbent on the respondent to put the question in that way. So it is clear to applicants precisely what is being asked of them. So what the respondent appears to be saying here is, well, we know question 4 refers to privileges being denied, revoked, or restricted in a hospital or other healthcare facility. But anyone reading that question should know that the question is actually far broader than that. And anyone who interprets the question based on the plain words is being, to quote Dr. Ross's statement, being pedantic. And with respect, my lady, that position is clearly not credible.
Well, pedantic is, I think, maybe a kinder word than what she might have intended. One can be pedantic without that corroding their character. The respondent's case really is that it was dishonest.
My lady, I agree. That is the respondent's case, and the appellant's case is that, and this is something that is admitted by the respondent, is that the answer that he provided to question 4 was true. So it's difficult how one can see how I can make the sort of logical leap from an admission that the answer that he provided was true to an allegation that he was dishonest. Mm-hmm. But I think,
well, I mean, again, not to repeat it, but just so that you are fully invited to address it. As I would understand it, there are cases really that it was dishonest because it was not complete. Not that it was untrue, but the dishonesty factor is that you knew that the question begged for responses broader than what you provided. And you quite coyly, would be the wording I would probably assign to it if I were describing the respondent's case. You quite coyly omitted those pertinent details that would give a fuller picture.
One can see how that a criticism of an allegation of dishonesty could be levied against the appellant if, for example, that answer to questions, the answers to questions 3 and 4 were the final word. If that was the appellant's position and he had provided no subsequent disclosure of any of the matters relevant to his answers to those questions, then and some of the authorities that the respondent relies on, and I will come to this later on, are examples of precisely those type of situations where an applicant is filling out a form. It provides an answer to a straightforward question, and those answers were shown on the evidence and proven to be factually incorrect. And he made no attempt at any stage subsequent to providing those answers to provide further information. This is not the case here. The case here is that he filled out an application form, a short 2-page application form. All of the answers that he provided on that application form were truthful. And then when the respondent came back to him with additional questions, and this is a point I'm going to come on to now, he responded with instructing a law firm, providing personal statements, providing documents, asking his attorneys in the US to provide long letters of explanation to the respondent so that the respondent had all the relevant context. It's important to remember that the appellant's application was not decided on the date that he signed the application form. The respondent's application was decided over a year later, also almost a year later rather, when the respondent had all the information before it.
So as a matter of just procedure, the application form would be submitted and addressed to, is it the permanent secretary? Shall apply in the prescribed form to the permanent secretary. And then it's the permanent secretary who then transmits the application form to the council. And then the council, through this credentials committee, will then further consider the merits of the application on the papers.
My lady, that's correct. I mean, certainly that's what happened in this case. And then once the committee had come to its decision, following a process of going back to the appellant and asking him further questions, and the appellant providing answers and documentation and letters, etc. That they came to a decision. They then provided written reasons, and those written reasons were provided as a matter of.
I'm just looking at it from the. What's the evidence as to what the appellant was expecting procedurally? He filled out this very brief form, and then he was expecting for that form, together with whatever supporting documents underlaid that form, to be considered by the credentials committee once the permanent secretary had passed off his application form to the council. Is that what his expectation was?
His expectation, my lady, and he deals with this in his witness statement. I will find the reference for you in a second. But
I mean, it's an open speech. You can just give me some idea.
So yes, his expectation was that the application form was certainly not going to be the end of the matter, and the reason why that was his expectation is because in the US, when one is making an application to be registered as a doctor in most states, what happens is you fill in a relatively short application and you provide evidence as to your medical qualifications and references and the like, and at that point you're then invited to an in-person interview.
Okay.
And you're asked, follow-up questions, additional questions. You're asked to provide further documentation. You can be legally represented, or you can appear in person. And the procedure can take, many months, and you can be asked to. So that was his expectation of how the process was going to work.
Thank you.
And that's important because another feature of the respondent's complaint, the appellant was allegedly evasive and dishonest, not only when he filled out the form, but via his conduct in the period after he signed the application form and while his application was still pending. And my lady, I think it's pretty clear from what I've said to date is that this assertion is not supported by the facts. And I deal with this issue at paragraph 62 to 63 of my skeleton, which again contains the relevant references. And I think it's, if you would indulge me, my lady, I think it's important for the court in coming to a view on this point to understand the sequence of events. If I may spend sort of 5 minutes just going through that, because it's important to understand what happened post the 28th of November to put everything in context. So could I ask my lady to turn over the page to 644 of the bundle, which is an email from Dr. Baisden, who is the Chief Medical Officer of the Bermuda Medical Services Group. What happened is that in mid-February, so a few months after the appellant had submitted his application form in November, the then Chief Medical Officer of Bermuda, Dr. Peakball, contacted the BMSG seeking answers to certain questions that had been raised by the appellant's application. And you'll see those questions that were asked in the email from Dr. Peakball, which is set out in her email on bundle reference 645, an email of the 18th of February.
Yes.
Dr. Baisden, two requests for the physician from the medical council were provide a summary of the Department of Justice case against Dr. Asad Qamar, including the resolution of the case, and provide confirmation from the Florida Board of Medicine that he's in good standing to practice cardiology. Now, what happened thereafter, as a matter of fact, is that there was some delay in responding to the respondent. And it appears that the respondent has factored this delay into its decision to reject the appellant's application. The court is referred, you can just note this reference, my lady, it's paragraph 33 of Dr. Ross's statement, which is at 677.
677?
The bundle, yeah.
Mm-hmm.
Yes, indeed. Where she states that it was of some concern to the committee that the respondent did not reply to the questions asked by Dr. Peakball faster than he did. And the appellant explains the reasons for this delay at paragraphs 18 to 25 of his second witness statement, which the bundle references for that are 284 to 286. Now we'll go to that now. Excuse me.
Yes.
But in short, the delay, my lady, was caused by some straightforward miscommunication between the appellant and the Bermuda and his prospective employer, and also because the appellant decided to engage, having realized that there were going to be further questions and there was an additional process to be followed. The appellant decided to instruct Kerry Olson to assist him in dealing directly with the respondents. And I would refer the court to the inter-parties correspondence that flowed between the parties from around April 2019 onwards. And this is at bundle references 644 to 667. Sorry, I'm taking you back to the starting point, which is February.
What's the page reference again, please?
644.
Yes. 644?
44, which is I'm taking you back to the.
Sorry, your voice is dropping, Mrs. Stevens. 644?
644, correct.
Okay, thank you. It may be the background noise. I'm sorry on my side.
Problem. So I've taken you back to the emails from between Dr. Baisden and Dr. Peakball in February.
Yes.
One turns over the page to 646 and 647.
Yes.
And I apologize, for some reason, these are two letters from Kerry Olson, which are in slightly the wrong order. There's the one on the left is dated the 29th of April, and the one
Yes, that's fine.
and it's a letter from Kerry Olson soon after we had been instructed to the chief medical officer. And the issue here is when we were initially instructed, there was clearly some confusion on behalf of the appellant, because the appellant had been issued with a registration number. That registration number is set out in our letter. Being unfamiliar with the process of applying for registration in Bermuda, the appellant was under the impression that once he'd been provided with a registration number, he'd actually been entered on it, he'd actually been registered. So the purpose of Kerry Olson's correspondence in April, 23rd and the 29th of April, was on instruction that the appellant had been registered. He had a registration number. He'd just not been issued with his certificate of registration so that he could proceed to apply for a work permit.
Mm-hmm.
So there was when Kerry Olson came onto the scene and we received our initial instructions, there was obviously had been some form of miscommunication between the BMSG and the appellant, and the appellant was clearly proceeding on a false basis, that he had in fact been registered.
As evident by your 23rd of April letter.
Indeed. And then if one then goes over the page to pages 648 and 649, these are emails in early May from Dr. Pete Ball to Mr. Henry Tucker of this firm. Mm-hmm. In response to our letters of late April. And if one looks at Dr. Pete Ball's email of the 3rd of May, in the second paragraph, she says, "For now, allow me to confirm that a decision on Dr. Asad Qamar's application to the Bermuda Remote Council is awaiting further information from him or his employers. If there is any misunderstanding on this point, we are eager to resolve it." So again, we're now in early May, and there seems to have been a miscommunication and a misunderstanding between the parties, and it's only in early May that the correct position is identified and is understood by the appellant, which is that he has not been registered. There is further outstanding information required by the respondent. And that further information. And so, sorry, if one turns over the page again and looks at the email at page 651, which is Dr. Pete Ball's email of the 7th of May to Mr. Tucker, myself, and Mr. Hansen. Again, if one looks at the second paragraph, Dr. Pete Ball says, "Dr. Qamar was never registered by the BMC. BMC vetting revealed 2 significant disciplinary sanctions by the state of Florida resulting from complaints." And she explains that that they require answers to 2 additional questions, and those are the same questions that she had provided to Dr. Baisden back in February. But for some reason, those questions don't appear to have come to the appellant's attention, but they certainly came to the appellant's attention by the 7th of May after Kerry Olson had been instructed. One then fast forward to the 7th of June. So
one moment, go back. These 2 questions did not come to the appellant's attention until when?
Well, it appears, there's no evidence as to precisely when he was aware of these questions. All I'm saying is that when this firm was first instructed by the
Oh, I see. He had the impression that he had already been registered, and it was only through. Okay, yes.
He had a registration number. As far as he knew, he'd been registered. He was just waiting for a certificate. Okay. And that's what prompted our correspondence of late April. Mm-hmm. And only in early May that it became clear that he hadn't been registered and that further information requests were outstanding from the respondent.
Yes.
So if one then turns over the page again to 653, this is an email from me to Dr. Pete Ball. And this is on the 7th of June, so it's about a month later. And just to give you the context, at this point, we'd been fully instructed by the appellant. We had read into the details of his case, and it took us, as one can imagine, quite a long time to get across all of the factual background and to collate all the necessary documentation. So we then responded to the medical council on the 7th of June, and that response included a covering letter from ourselves, which is over the page on 654. And also a personal statement and a large index bundle of documents which accompanied Kerry Olsen's letter of the 7th of June. Now, those are actually elsewhere in the bundle, my lady. They're not in the run of inter partes correspondence at this point of the bundle. But if one looks at bundle reference 297. Sorry, I'm just turning it up. 297. One can find the covering letter that we were just looking at, dated the 7th of June, and then over the page, there is a 3-page personal statement provided by the appellant, and that goes through to page 300, and then at page 301 there is an index of documents that we provided, or the appellant attached to his personal statement, and that bundle of documents is contained from 301 through to page 487 of the bundle. So all of the documents that the appellant provided on the 7th of June in response to the respondents' questions are in the trial bundle, and one can see that they were very significant, including, for example, copies of the settlement agreement entered into between the appellant and the Florida Department of Health, as well as all sorts of other legal and character references, etc. So
tell me something, Mr. Stevens, just to clarify for me.
Yeah.
These are obviously all the documents once it was relayed to your client through your services, that there was an issue arising. But what were the documents that were originally submitted with the application? So the 28th of November 2018 application form, am I wrongfully assuming that there were documents supporting that application form, or was it just the 2-page document that was submitted?
My understanding is those documents are not in the bundle, and I'm sure if I'm wrong about this, the respondents' counsel would correct me. But my understanding is that there were documents submitted along with the original application form, but most of those documents were to do with the appellant's medical qualifications and credentials, his license to practice medicine in the state of Florida, things like that, evidencing the fact that he was qualified to do the job. But as for the documentation that goes to the allegations that were made against him and all of the subsequent events, those documents were provided to the respondent, but they weren't provided in November, they were provided in June. I was taking the court through that correspondence to make the point that there was nothing sinister or untoward about the delay in responding to the respondent's questions, albeit that the respondent appears to have read something sinister into that delay. But if one reads the correspondence in context and understands what happened, one can see that there was clearly a miscommunication. The appellant was proceeding under a misapprehension, and so were we, to be perfectly honest, until it was confirmed to us in early May what the position was, and thereafter we were instructed to fully cooperate in answering the respondents' questions, which is what we did. And the important point is that in all of the subsequent, and I've made this point a number of times, so I won't labor it, but the important point is that the appellant provided fulsome and honest answers to all of the follow-up questions asked by the respondent. And those responses were supported by a very significant amount of documentation, including court documents and detailed letters of explanation from the appellant's attorneys. Mm-hmm. And this was all while the appellant's application was still being considered by the respondent. They had not come to a view as to whether or not to confirm or reject this application. If I could just quickly refer to the court to the appellant's evidence on this point, which is at paragraphs 22 to 25 of his second witness statement, which is at pages 285 to 286 of the bundle. And my lady, I should be, in terms of this point, I should be done quickly in the next 3 or 4 minutes. I'm then going to deal with good character, and I'm going to leave my submissions in relation to the respondents' authorities until closing, because I'm conscious of time and the fact that.
Well, I think we contemplated, I'll have to refresh my memory as to when the appellant will give his evidence. He's going to be submitted directly for cross-examination, or are you going to be?
Indeed.
Okay.
And all I was suggesting is that I had some submissions to make in relation to the respondents' authorities, but given that I've been a little laboured in my submissions this morning, I thought perhaps I will defer those until closing, so that the respondent can start with its opening submissions in good time.
Sorry, my lady, just,
Yes.
sorry, I was just going to say that I know that what we had outlined was that there was going to
Morning
be
would be
some,
opening submissions.
right, and that there was going to be some re-examination of Dr. Ross and cross-examination of Dr. Gear. But I don't think that the court has been advised that we're no longer doing that, so it's only the cross-examination of Dr. Qamar. I don't know if that makes a difference as it relates to time.
I see, because Dr. Ross, Dr. Ross's evidence was envisaged for day 2.
Right.
My lady, I don't know if I'm not sure if you're looking at the current version of the indicative timetable, but if memory serves correctly, I'm
looking at my notes from the hearing of the 24th. I didn't realize that a timetable, I haven't seen a timetable if one's been submitted.
I haven't either, I must admit, Sam.
Apologies. An indicative timetable was, I believe, was submitted to the court. But in any event, after the directions hearing, Ms. Francois informed me that it was no longer Dr. Ross's intention to provide live evidence.
Right. So you will not be cross-examining Dr. Ross?
Exactly. So the only cross-examination and re-examination that will happen in this appeal will be that.
That's very helpful. Thank you. So then that allows us to recover. I mean, it doesn't seem that we're overly behind in any event, because what I noted was that the morning was going to be fully taken up by opening submissions in any event, and that the appellant's cross-examination would start in the afternoon. What's the position with Dr. Greer?
We're not cross-examining Dr. Greer either.
Okay. So
I only raised this, right. I only raised this because my learned friend had indicated in terms of time. But I think that we do have sufficient time because those 2 persons are now out of the picture.
Okay, that helps a lot.
So if he wishes to continue, I have no objection, which is what I was trying to say.
Okay.
Okay. Well, I mean.
Well, then you can from if I'm reading Ms. Francois well enough, she seems to be expressing her agreement for you to continue until we take the lunch break, and the cross-examination of the appellant can start at 2:30.
I'm grateful, my lady. I should be done by then. It depends what time we are. Are we envisaging taking lunch at 1?
I was hoping you would have been finished by 12:30.
I've got a little way to go in terms of, because I've still got to deal with the test for good character, which
okay. Well, we'll go as long as we need to.
Okay, but then, so what I would suggest then is I'll finish what I'm discussing now in terms of the process. I'll deal with good character, and then in terms of my submissions in relation to the authorities, I will leave those for closing.
Yes.
Happy to do that.
Yes.
Okay. My lady, thank you.
Mm-hmm.
So I was making the point, my lady, that it's important to recognize that there is no allegation made against the appellant in this case by the respondent that he provided dishonest answers to any of the respondent's additional follow-up questions.
Yes, that's correct.
What's principally said against the appellant is that he should have provided all of that information at the outset when he signed his application form. And the fact that he didn't has given the respondent cause for concern as to his character, as to his integrity. And as explained, and you asked the question earlier, what the appellant's expectation of the process was. He was under the impression, based on practice in the United States, that the application form was the very start of a much longer process. And the idea.
So this is why I wanted to know what documents he submitted in support of the application form. I was curious as to how voluminous the package was, whether or not it was simply a resume, a bio, a statement of his academic qualifications and professional experience, or whether or not there was a big bundle of documents and it was done quite thoroughly and in detail, but omitted the documents that the respondent complains of. It might have given rise to some level of impression in terms of how voluminous those documents were.
Indeed, my lady. I do not have a list of the documents that were provided at the time, but I can seek instructions. I can give the court some guidance on that point.
Okay, thank you.
So the point I was making is that the allegation against him is that he should have provided all that information at the outset, and the fact that he only provided that information later, albeit while his application was still under consideration, is somehow a cause for criticism and calls.
It impugns his character, is what the respondent is saying. That's quite severe, is obviously what you would say in response.
Indeed.
There was nothing untruthful about the information that was submitted, and it was quite thoroughly done once he had engaged Carrie Olson to represent him.
Indeed, my lady. And I think you have the point, and I don't need to labor it any further. I think if there was an allegation that his responses to all of the follow-up questions were replete with factual inaccuracies or dishonest answers, one can see how the appellant would have no cause for complaint. But the point is here is that every single stage of the process, when he was asked a question, he provided a truthful answer.
Yeah.
Now, you can argue whether or not his answers provided in the application form were complete or incomplete. We say he provided a complete answer to a very simple question. The respondent says he should have provided or he should have caveated every single answer of no on that form. But the point is, he did caveat it. He did caveat it at great length and at great expense much later in the process. Mm-hmm. So, my lady, that's all I have to say about the facts. And I wanted to move on, if I can, to the question of what good character means in the context of an application to register medical practitioners. And my lady, I dealt with this for reference at some length at paragraphs 20 to 37 of my skeleton. And I don't propose to sort of rehearse the arguments there, but the arguments are clearly set out for the court's attention. Now, in rejecting the appellant's application for registration, the respondents said it had regard to the British Home Office guidance published in support of the British Nationality Act 1981, which guidance contains a defined test to be applied to the question of good character, and that guidance is set out in the written decision that was originally provided by the respondent. I don't have the reference, but I can get it. But as I pointed out in my skeleton, at paragraphs 29 to 37, this in our respectful submission seems to be a very odd starting point for a medical body in Bermuda, given that obviously it was not dealing with a nationality application. And since it was obviously looking to the United Kingdom for guidance, the British equivalent of the respondent, the General Medical Council, has put forward a very clear statement of how good character should be assessed. And that statement and the reference is contained at paragraph 32 of my skeleton. And the General Medical Council's assessment of how a medical regulatory body like the respondent, like the General Medical Council, should assess character is that having regard to the individual's entire character and antecedents, would a right-thinking member of the public with full knowledge of the proven facts and matters regard him as being of good character for the purposes of registration as a medical practitioner, or would the registration of that individual, in light of his known character, be such as to bring the profession into disrepute? Now, as I said in my skeleton, my lady, paragraph 36, the central theme of the good character test that's put forward by the General Medical Council in the UK when assessing the registration of medical professionals is that only proven facts should be taken into account. And by proven facts, I'm talking about proven facts of wrongdoing. Now, there's no mention of the British Home Office guidance as to the British Nationality Act 1981 in the respondent's skeleton argument for this appeal. So it's not clear from our side whether the respondent still now relies on that guidance as being of appropriate application in this case. Instead, the respondent relies now on the Privy Council's decision in Lane versus the Attorney General of Grenada, which is an authority.
That was to do with an admission to the bar.
Indeed.
Application for admission.
Yes, indeed. And that concerned, in slight contrast to this case, the application for admission of a appellant who had been convicted of multiple murders, and indeed the assassination of the then sitting president of Grenada, for which he was originally sentenced to death.
Very different facts.
Very different set of facts to what we're dealing with here now. But having said that, in terms of the legal principles that emerged from that case, as opposed to the facts, the appellant is happy to adopt and rely on this case because it's the appellant's position that the ratio of this case actually supports its position with regard to the assessment of the appellant's character. Now, the board, the Privy Council in this case observed that in its view, the good character test has two facets. And the first facet being the candidate's attributes and the risk of damage to public confidence in the profession if the applicant in question is registered.
I mean, I'm bound by the analysis and laying out in any event.
Indeed, my lady, absolutely. I would accept that. As I say, the analysis I think is actually helpful to the appellant's case, and I think the analysis in Lane can be read. It can be read in conjunction with the General Medical Council's indicative test of what good character means, and I'll explain why in a second. But as to the candidate's attributes, which is the first facet of good character, the key section of the board's decision is at paragraphs 36.
Okay, so shall I open up the case?
Sorry, indeed.
You said to me you weren't going to take me through authorities, but I suppose the Privy Council decision should fall to an exception.
Indeed. I only on a couple of occasions, but I think this case is obviously very important. So
okay, I have it.
So paragraphs 36 to 38, my lady, if you could turn to those paragraphs, and it's the speech of Lady Arden, which I think it'd be helpful just to run through what she says. Which 36, she says in 36, for understandable reasons, a wide range of professions, and not just the legal profession, have good character and competence conditions for entry into the profession. Those professions include those in which members of the public may place great trust, such as medical and legal professions, members of these professions, once admitted, have to observe high standards of behavior in both their private and professional lives. And they may face disciplinary charges if they fail to do so. The content of good character condition may vary according to the profession. The person or body which is to be satisfied about conditions of entry may be given powers to investigate or obtain evidence. And then if one skips down that paragraph and in fact goes to paragraph 38, Lady Arden says, the good character condition must clearly refer to a good character appropriate for being an attorney at law in Grenada. What she's effectively saying there is the test is one has to look at the sector, one has to look at the profession, specific profession into which the applicant is being admitted and decide whether or not he's of sufficiently good character to be admitted as a member of that profession. So applying Lady Arden's test in Laney to this case, what this court has to decide is what good character or what good character means, rather, in circumstances where an applicant is seeking registration as a medical professional in Bermuda. And we say in those circumstances that the British Nationality Act, the British Nationality Guidance, which was relied on by the respondent in its written submission, in its written decision, was not the correct starting point when assessing whether to register an individual as a medical professional in this jurisdiction.
Tell me something, Mr. Stevens. The process in cases such as this one is that an application for registration will be submitted. Let's suppose for a moment it's approved. And the appellant then has to go on to make an application to the Department of Immigration for a work permit. Did I read in the submissions of either you or Ms. Francois that the general practice is that the Department of Immigration will pretty much process the application for a permit once the medical council has approved the registration process? Yes?
That is my understanding of the practice. That's actually not what the Act says. The Act seems to suggest it should be the other way around, isn't it? That you can't be a duly eligible applicant under the Act unless effectively the Department of Immigration has blessed, has indicated that you have a work permit or you will be granted a work permit.
And part of the order of the applications being considered may not be crucial to this particular point, but part of the process in the application before the Department of Immigration involves an assessment of good character. Is that correct?
That's my understanding, my lady, yes.
Is it the usual practice that good character will be separately considered by the Department of Immigration and then separately considered as part of the application process before the medical council?
I'm to be frank, my lady, I don't know the answer to that question. It would seem to me, as a matter of practice, I would have thought the Department of Immigration would reserve to itself the right to decide that question fresh, given it's an immigration issue rather than a professional registration issue. But as to how it works in practice and to whether or not the Department of Immigration takes notice of a conclusion by the medical council that somebody's a good character, I would say I would refer to the respondent's superior experience of the registration process.
Mm-hmm.
So, my lady, I was making the point that in circumstances where the question is what good character means in the circumstances of registering a medical professional in Bermuda, as per Lady Arden in Laney, we say that the British, the nationality guidance submitted alongside the British Nationality Act was clearly the wrong starting point, and that the better starting point is the very clear guidance that's been provided by the UK's General Medical Council, in the absence of any guidance that is available in this jurisdiction. And we say if that guidance is applied to the facts in this appeal, then the court must get to a position where it regards the appellant as being of good character. So dealing then with the second facet, so we've dealt with the first facet of the good character test under this Privy Council decision in Laney, and then dealing with the second facet, which is the question as to whether there would be a risk of damage in the profession in the event that this appellant was registered as a medical practitioner in Bermuda. And I would like, if I may, to refer the court to the respondent's apparent approach to this question, which is neatly captured at paragraph 100 of Dr. Ross's statement. And that paragraph can be found at bundle reference 694.
Can I just note it, or do you want me to open?
If you wouldn't mind turning it up, my lady, I think it's important because I'm going to make submissions in relation to this statement.
Okay. You said 694?
94, and it's paragraph 100 of Dr. Ross's witness statement. So, do you have it, my lady?
Yes, I do. Which paragraph you said, sorry?
Paragraph 100.
Yes, I have it. The long and extensive history.
So the long and extensive history concerning the appellant as described above is nothing like what I have seen before in any applicant applying for registration. The committee is concerned that the appellant's conduct is indicative of the general manner in which he might likely conduct himself should he be registered to practice in Bermuda, which has the real potential to tarnish the public's,
Yes, which has a real potential to tarnish the public's trust in him.
And therefore the medical profession. And it's the next section that I'd like to focus on, my lady. The committee further notes that the Bermuda public could conduct their own Google and online searches about the appellant if he moved to Bermuda and discover a wealth of information about him and his past conduct in the United States, thereby calling into question their own trust in him, as well as the integrity of the Bermuda Medical Council, whose job it is to sift out applications that should have been refused. Now, it's our submission that this is quite an extraordinary statement from Dr. Ross.
You would pounce on that statement.
Sorry, my lady?
You would pounce on that statement.
Indeed. Because what I would say about that statement, my lady, is that Dr. Ross and the respondent have clearly fallen into the trap of concerning themselves with how a decision to register the appellant as a medical practitioner in Bermuda may be subjectively viewed in the court of public opinion. And that the respondent has absolutely no business concerning itself with the subjective views of the Bermuda public in deciding whether to register medical practitioners is clearly articulated by Lady Arden and Lord Kerr at paragraphs 43 and 76, respectively, of the Privy Council's decision in Laney. And I'll take you to those paragraphs, my lady, because I think this is a very important point. And you'll see that paragraph 43 of Lady Arden's speech comes under the heading B, risk of damage to public confidence.
All right, can I close out the hearing bundle?
You can close that page, as long as you have that point, that paragraph. Yeah. Great, thank you. One looks at paragraph 43 of Lady Arden's speech, which is, under the heading risk of damage to public confidence in the profession. she states, whether there is an appropriate level of public confidence is also a matter for the assessment of the Supreme Court, and that this was the Supreme Court of Grenada. As Sir Thomas Bingham said, confidence must be well-founded. Thus, any lack of confidence by the public must be justifiable on an objective basis. It is not enough that the public would misguidedly not have confidence in a particular candidate. It is not a part of its function to assuage public opinion. So the public confidence requirement is not inevitably satisfied by adducing evidence of opinion of witnesses, even if those witnesses are the highest standing in the community. And so that we would say that section of Lady Arden's speech is critically important when looking at paragraph 100 of Dr. Ross's witness statement. And I would also refer the court to paragraph 76 of the judgment, which is in the speech of Lord Kerr. And again, he's addressing the second facet of the good character assessment. And he says it's sort of 3/4 of the way down paragraph 76, my lady. Well, the whole paragraph is relevant, but I would divert your attention particularly to the sentence that begins thus.
Yes, I see it.
Thus, the court must examine for itself on an objective basis whether the applicant for admission is of good character. That examination should comprehend whether the candidate is possessed of the qualities necessary to command public respect, but the decision on that question is one for the judge based on his or her assessment and not on any assumption as to what the public's reaction might be. No. And again,
That targets your point on all fours.
Indeed. And that's why we say the General Medical Council's test of good character is on all fours with Lane, because it incorporates an objective standard. It says, would right-thinking members of the public, in full knowledge of the proven facts and matters, regard him as being of good character for the purposes of registration as a medical professional? So we say when one reads Laney and the speeches of Lady Arden and Lord Kerr in conjunction with the very clear objective test set forward by the UK General Medical Council as to the meaning of good character, we think that is a reasonable and appropriate standard for this court to adopt. And it's our respectful submission that the court should put itself in the position of a right-thinking member of society with full knowledge of the proven facts in this case, and it should form the view, we say, that a right-thinking member of society would not think by any means that there was a risk of damage to public confidence in the medical profession if in Bermuda, if the appellant was registered. Now, my lady, at this point, I was going to deal with some of the respondents' authorities, but I think I will conclude there, unless the court has any further questions for me. Those are my open submissions.
No, I'm grateful to you for such thorough submissions. I think that helps tremendously. I wouldn't usually expect to receive such detailed submissions in an opening speech, but I think in this case it was appropriate and helpful. Thank you.
Thank you, my lady.
That being the case, I note the time is now 1:45 or just approaching 1:45. It seems to me that we should adjourn to 2:30 unless Ms. Francois wants to get a start. It's a matter for you.
No, my lady, I would prefer to adjourn to 2:30. And also, can I apologize a little earlier when my screen went blank? I actually got kicked out for a bit. So I didn't turn it off intentionally. Apologies.
No, I did not notice, and it concerns me that I did not notice because there are so many persons joined. I don't have a large computer screen in front of me, so I don't have sight of everyone on the Zoom call in one screen. I have to scroll through. And because I had been focused on Mr. Stephen's submissions, I only had him in sight, I have to say. But that does raise a point that if you or Mr. Stevens in particular, or the appellant drops from the Zoom appearance, I think you'll have to make contact with Ms. O'Connor or the registrar directly on an urgent basis, or you could even send an email to the Supreme Court generic email address, and I'll see if I can pull that up on my screen so that I can see it pretty quickly. But otherwise, I'm a little concerned that that escaped my notice.
Yes, I mean, it's not as bad because I know that Miss Snelling was on as well. I didn't miss that much, but I definitely wasn't on for a few minutes.
Well, I mean, this is live streamed on YouTube, and so
Right.
you can always refer to it if you feel that you've missed anything. It will be there for your reference. So I think that doesn't really give rise to any further concern. So shall we adjourn to 2:30?
Yes, I'm grateful.
Yes? Okay, thank you.
Thank you.
Okay, good afternoon, everyone. Can everyone see and hear me clearly?
Yes, my lady.
Okay, good afternoon, Ms. Del Francois. Do we have Mr. Stevens connected to the?
Yes, I'm here. Good afternoon, my lady.
See, I'll just do one scroll to see who's here. Thank you, Mrs. Stevens.
My lady, I should also mention that Dr. Doherty has now joined us this afternoon.
Sorry, just one moment, Ms. Joy. I'm having, for some reason. Good afternoon, Ms. Del Francois. Do we have Mr. Stevens connected to the?
Yes, I'm here. Good afternoon, my lady.
See, I'll just do one scroll to see who's here. Thank you, Mrs. Stevens. All right, that should settle that. Okay, Ms. Del Francois?
Yes, my lady, I just mentioned that Dr. Doherty has now joined us this afternoon.
Thank you. Good afternoon to you, Dr. Doherty.
Good afternoon, thank you.
So,
Yes,
my
Mr.
lady,
Francois, are you ready for cross-examination of the appellant?
I am, but just a housekeeping matter, my lady. Are you actually taking notes of the answers? Should I stop after each question, or are you going to be reviewing the recording? I just want to know how fast it is.
It's my intention to operate at the same pace I would if we were sitting in court. The fact that we have a hearing, I still need to obviously follow the cross-examination. So I would like it to be at a generally reasonable pace, but you'll find that I am not going to make an attempt to write down every word that you say or every word in response.
Okay, very well. Thank you. I just wanted to confirm.
Apologies, my lady. Sorry for cutting across. Is it the intention to proceed with the cross-examination now, or is the respondent going to be giving some opening submission? Sorry, I'd misunderstood what procedure we had agreed to.
The intention was to proceed with the cross-examination so that any responses that Dr. Qamar provides can be used for our closing.
Well,
Right.
I mean, that's a matter for the respondent. I see no reason why we can't proceed to the cross-examination.
Absolutely. I just wanted to check. I can't see Dr. Qamar on my screen. I just want to make sure that he is connected.
Okay, one moment.
Confirm that he's there.
He is. I do see him.
I do see him, but he's muted.
You're still muted, Dr. Qamar.
My apologies. Can you hear me now?
Yes, very clearly. Thank you.
Your Honor, thank you.
All right, Ms. Del Francois, I do think that if we don't operate at a reasonably slow enough pace, this may become more difficult than necessary, simply because we are doing this by Zoom. And so you will have to, I think, probably feel out the pace of your cross-examination to allow for the fact that there are going to be now 3 people without muted buttons on the call.
So, my lady, I note that the instructions were that witnesses should have a Bible present so they can take the oath.
Let me get my court associate. Where's the court? Miss O'Connor or Miss Asad? Yes, thank you. Dr. Qamar, tell me, is it your intention to swear on the Bible or to affirm in giving your oath?
Your Honor, I would rather give an oath on the sanctity of this court and the fairness of this court.
Okay, so if you're not going to swear in the Bible, it will be an affirmation. The court associate, Ms. Asad, is going to read out the affirmation card, and you'll just have to repeat after her, okay?
Certainly.
Thank you.
Good afternoon. I do solemnly and sincerely affirm that the evidence that I should give shall be the truth, the whole truth, and nothing but the truth.
I do solemnly affirm that the evidence that I will give should be the truth and the whole truth.
And nothing but the truth.
And nothing but the truth.
Thank you.
Thank you, Ms. Asad.
Okay, thank you, Dr. Qamar. I have a few questions for you. And as the court has indicated, I'll try to move at a reasonable pace, but it's also the fact that I would ask that you give your answers at a reasonable pace as well, because I'm also recording that.
Certainly.
Thank you very much. So, Dr. Qamar, can you tell us what the current status is of your ability to practice in the U.S.?
I have a clear and active license in the state of Florida, and it was renewed till January 31st of 2021. And about a week ago, it was renewed for another 2 years. So it's now current, clear and active till 31st of January, 2023.
Yes.
So just to confirm, this means that you're no longer required to be supervised by another doctor?
Yes, that is true.
And you're currently practicing in the U.S., correct?
Correct.
And can you just advise what it is that you're currently doing?
I'm practicing all facets of cardiology, clinical cardiology, non-invasive cardiology, including echo and vascular and CTAs, as well as nuclear cardiology and PET perfusion imaging, and certainly a fair bit of interventional cardiology. In interventional cardiology, it's both coronary as well as endovascular medicine.
And can I confirm, is your practice, is this on a permanent basis or are you a consultant? What's the nature of your practice?
No,
Mr. Contour, can I ask you to keep your voice elevated? I find that I'm struggling to hear you, not as much as I am Dr. Qamar. I can hear him clearly.
All right, sorry, my lady. I think
Thank
maybe
you.
I'm too far away. I'll lean forward a bit. Did you get that question? I was asking if this is on a permanent basis or as a consultancy?
Yes, it is on a permanent basis. It's a full-time employment.
And how often would you say you work a week?
I work 5 days a week, usually from 8 in the morning till about 12 midnight.
And you're now, sorry, and you're now able to accept Medicare and Medicaid patients?
Yes, I am reinstated and re-enrolled in the federal healthcare programs.
And can you confirm who is it that you work for?
I work for Central Florida Heart Group, which is a cardiology practice, non-invasive and invasive.
Okay, so you've basically managed to somewhat rebuild your medical practice in the US?
Ma'am, the practice actually was never lost. I had several thousand patients and they continued to follow me throughout this period. And in fact, there are more patients in the practice now than there were throughout the key TAM investigation.
So while you say that your practice was never lost and you actually have more patients now, so why is it that you wish to work in Bermuda?
May I clarify what I meant by that? So the practice was bought by the University of Florida through the bankruptcy. in 2016. And my last working day with my practice, the original practice, ICE, the Institute of Cardiovascular Excellence, was the 31st of December, 2016. The university, as they bought the practice from me, had asked for a 2-year non-compete for me. And they had asked for me to move myself 20 miles away in a town called Williston. And I moved over there and I continued to work in Williston. And the patient population followed me to Williston for a period of 2 years. And now that after 2 years, when I came back to Ocala, the practice came back to Ocala. Yes, that is exactly the point I wanted to make. I wasn't coming to Bermuda because I was running away from United States. I wasn't coming to Bermuda because I couldn't practice in United States, and therefore I thought I'll do a gig in Bermuda. I was coming to Bermuda with a commitment of creating a world-class cardiovascular program if I could. And that should show the court my commitment that despite the fact that I have a clear and active license, despite the fact that I can freely practice medicine in the United States, despite the fact that my current contract pays me almost twice as much as my existing contract in Bermuda, I'm still wanting to come to Bermuda if given the opportunity. And I have gone through the difficult task of this entire process of 1 year of trying to get a hearing in front of the court against the decision by the BMC.
So you say that you're coming because you want to help to build a world-class program.
Correct.
And that's your main
A
reason.
world-class cardiovascular program, he said.
Cardiovascular program. And you say that's your main reason.
That is my sole reason.
Now, in May 2018, you were approached by Mr. Gear, Donald Gear, about coming to Bermuda.
Correct.
And heading up the lab.
Correct.
Yeah. And you accept that Mr. Gear is not a physician, correct?
Correct.
Well, let's turn to page 231 of the bundle.
Yes.
And let's look at paragraph 10 of Mr. Gear's statement. Yes?
I'm there.
Okay. And you see he says that he was shocked to discover the very limited cardiologist services available on the island. That's the first sentence, paragraph 10.
I see that.
And we're at page 231, my lady.
Yes.
Do you have that? Yep.
Yes.
Okay. And if we go to 234, paragraph 27.
$27?
Yes.
I'm sorry, did you say 27?
It's page 234, paragraph 27.
Correct. Okay.
Okay. And you see here, Mr. Gear speaks about the benefit of having the lab in Bermuda.
Correct.
He says it would increase the patient case. But I'm going to suggest, isn't it the case that neither you nor Mr. Greer consulted any of the local cardiologists before coming to this conclusion?
It is correct that no local cardiologists were consulted, but there really were no interventional cardiologists that I know of on the island. I do know that, and I quite frankly knew nothing about the cardiovascular market or medicine in general in Bermuda before early 2018. But when Mr. Gear approached me And after his approaching me, I got in touch with a BMSG and I had extensive discussions with them. It became clear to me, I certainly would not say that cardiology is in its infancy in Bermuda. I think there is a good level of non-invasive cardiology being practiced in Bermuda. I think it would be inappropriate to say that there is none. I think a very good quality non-invasive cardiology is being practiced. But the fact is that there was no invasive or interventional cardiology available on the island. And the fact is that the patients still have to be transferred out of the country to other places to get simple invasive services like diagnostic angiograms, let alone interventions.
Can I take you to page 499 of the bundle?
I'm there.
Okay, and you'll see the first sentence, while it indicates, now, sorry, this is Dr. Doherty's statement, just to be clear.
Right.
So the first sentence talks about how that Dr. Gear recruited you by telling you that there is tremendous need for a highly experienced cardiologist in Bermuda, and there was no invasive or interventional procedures.
Correct.
Yes, but isn't it the case that there are 4 cardiologists? Dr. Gear outlines them here in Bermuda.
Still, Francois, can I just remind you to keep your voice elevated?
Sorry.
Thank you.
Sorry.
I know it's not obvious when you're behind a computer screen, but I can hear you dropping your voice, and it's difficult for me, your condition in my background.
I'll put my laptop a little bit closer. I have the
Okay. No, that's fine.
the binder here, so it's
Okay.
pushing it back.
Thank you.
You mentioned that there are 4 cardiologists in Bermuda, and they may have invasive or interventional experience, and that's wonderful. But the question is, are they able to discharge those duties in the environment currently in Bermuda?
So I'm not going to read through the entire paragraph of Dr. Doherty's statement, but I'm going to put it to you that they are able to disclose their duties.
Pardon me?
I said I'm not going to read through the entire paragraph, but I'm going to suggest to you that they are able to discharge their duties. And what do you say to that?
Do you mean that they are currently providing cardiac catheterization and coronary and peripheral interventional procedures in Bermuda?
This is in response to your answer to say that they're not able to discharge their duties. And I'm going to suggest to you that they are.
Sorry, let me just be clear, because I understood Dr. Qamar to be specifying the types of services that are not available in Bermuda, as opposed to making a generic statement that the cardiovascular specialists are unable to discharge their general duties.
Thank you, Your Honor. That's exactly what I was stating.
All right, thank you. Thank you for the clarification. Let me take you to page 251 of the hearing bundle.
261?
251.
251, thank you.
This is the PowerPoint presentation, of Mr. Gear.
Right.
Right. So at 251, you'll see under extremely specialized staff to complete interventions. Sorry, my lady, I'll wait until you get.
Yes, thank you. What's this document?
This is a PowerPoint presentation of Dr. Gear. I'm sorry, Mr. Gear.
I see. Give me a little context, please, before you
So
ask.
this is the presentation as to why Bermuda is in need of the lab that they wish to set up.
Okay, thank you.
Okay. So underneath so we're back at 251, underneath extremely specialized staff to complete interventions. Yes?
Yes, I have it. You have it, Dr. Qamar?
Yes, I do have it.
Okay, thank you.
And you accept that it says that you'll only be doing 10 to 15 interventions a month, which is 3 days of work a month, correct?
Correct. I must point out that I don't know the context, if that is known to you, but the plan was to start out with that volume so that the staff gets used to the new environment, to the new facility, because these kind of services, of course, cannot be delivered in a vacuum. The entire system has to be set up, including the EMS system.
Okay, but what we have before us does not provide that. This indicates that the interventional staff would only work 3 days a month.
Starting
You
out,
accept
yes.
that? Well, it doesn't say starting out. So I'm suggesting to you that this document says that you'll be working 3 days a month, correct?
Correct, it does.
Okay.
Ms.
Now-
Phil Francois, sorry to interrupt your cross-examination. It occurs to me why it might have been beneficial to hear from you first, but you can maybe answer the question very briefly. I'm trying to appreciate the relevance of this line of cross-examination. I want to give you quite a bit of latitude just to allow for the possibility that it will become clearer in due course. But I understood your general case to really land on the question of how Dr. Qamar presented his information to the council in the application process. So it's not yet clear to me, and in fact, I'm even willing to allow you to continue your cross-examination if you feel that it will become clear shortly, or you can just give me some assistance.
I can give you some assistance, my lady. So Dr. Qamar has indicated that his sole reason to come to Bermuda is to, assist with the lab. He feels that Bermuda needs this type of intervention. Now, Mr. Gear has indicated that they'll be working 3 days a month. And if I take you, which I will take Dr. Qamar to Dr. Doherty's statement, that would still give them a profit of approximately $5 million a year.
Mm-hmm.
So my point is that Dr. Qamar, in completing that application form,
Mm-hmm.
knew very well that he was completing it dishonestly, as we would put our case, due to the profit that he stands to make, and not due to the fact that he wishes to come here on the basis that, he wants to set up this.
Okay.
Set up.
So these are things that I think in your closing speech will become quite
yes.
to me. Okay.
Most definitely, my lady.
All right. Thank you.
So if I'll continue on with
Yes.
that line of questioning. So I think you've already accepted that you'll only be working 3 days. Yes. And I don't know if you...
Well, no, his answer was that from in the initial statement, you put it to him that that's not what is represented in this PowerPoint.
Yes, yes.
But his answer remains that was he was intending to only start with that kind of volume.
Yes, yes. Thank you for the clarification,
If,
yes.
if you will please allow me, first of all, just implementing these services is going to take a very long time. I think it will take at least a year, if not more, to place a cardiac cath lab in Bermuda. I think it will definitely take more than a year. There has to be a physical structure which is appropriately built, and it has to be built to the specifications of JACO or ARCA or one of those organizations. Number two, the equipment has to be procured and installed on the island. And then it certainly cannot exist in a vacuum. The EMS system, the training of the staff, the coordination with the hospital. It doesn't have to be outside the hospital. It could be inside the hospital or as a part of the hospital. A lot of those discussions need to take place. And a lot of work needs to be done before we have the first case that ever happens in Bermuda. And then, of course, that does not necessarily mean that, as I have pointed out before, I intend to practice all facets of cardiology. So my work in Bermuda is not going to be just 3 days a month. Just wanted to clarify that.
And if I can take you to page 495 of the bundle.
295?
495.
495.
And this is Dr. Doherty's statement.
Okay.
And I'm at paragraph 14.
Right.
And the last sentence of paragraph 14. And here, Dr. Doherty indicates that even with Dr. Qamar working only 3 days per month, the billings generated could be between 3.6 million and 5.4 million in just 1 year. Right?
With all,
you accept that it says that, right?
yes, I would accept that it says that. Yeah.
Right. And now you just explained to us that you'd actually be working more than 3 days a month.
Correct.
Right. So based on this, the projected generated fees would be even more than what Dr. Doherty has here.
I would like to remind you that I just stated that I'll be providing all facets of cardiology, non-invasive and invasive. And we said that invasive part is going to be 3 days a month, as you had pointed out. So it would be unfair to extrapolate these 3 days now to an entire month of interventional work. Plus, I quite honestly don't know how these numbers were arrived at. And I have experience of owning and operating outpatient cardiac cath labs. With all due respect, I don't know if Dr. Doherty has ever owned or operated an outpatient freestanding cardiac cath lab. And I have no idea if he has any idea what the overheads of such a project would involve. I want to point out, if you look at the numbers of ICE, out of the $18.1 million which were collected, $16.4 million, not according to me, but according to the Wall Street Journal, were the overhead of the cath lab, and the rest was the profit. So to make a fantastical statement that a profit of 3.6 to 5.4 million will be generated by working 3 days per month, I think it's just unbelievable. I think I'm shocked.
Well, I'm going to put it to you that that is the profit that would be generated by virtue of working 3 days a month. Do you accept that?
I disagree. I think it is, those numbers make no sense.
And I'll put it to you that you've now explained that you'll be working even more than 3 days a month, and that the profit would generate would be even more than what's stated here.
With all due respect, as I pointed out, my full-time work will involve non-invasive cardiology also. So for clarity of the court and Your Honor, I would once again make the statement that I will not be practicing invasive and interventional cardiology for the entire month.
Dr. Qamar, we understand what you're explaining, but that wasn't the question.
What is the question?
We've moved past the 3 days. You indicated that you're not going to be working for 3 days. You're going to be working for more than 3 days.
Correct.
Right? And I'm suggesting to you that this paragraph, which outlines the profit that you stand to make, the numbers would even be higher, because now you're telling us that you're not going to be working for 3 days a month.
But Mr. Francois, that's an unfair question, because he's made it clear that he doesn't accept the accuracy or the fairness of the figures in the first place. So it follows that he would not agree, or he could not possibly agree, that those numbers would escalate simply because he's also going to be doing non-invasive interventional work.
I'm grateful, my lady. I'm grateful, my lady. I hear what the court is saying. So based on all that we've gone through, Dr. Qamar, I'm going to suggest to you that the profit is the main reason that you wish to come to Bermuda, and not what you've stated previously, that it's, you feel that, sorry, I forgot to say that you want to create a world-class program for Bermuda. It's really the profit that's driving you.
I would wholeheartedly and vehemently disagree, but I would certainly respect your thought process, your thinking. I certainly can't seem to change that.
Thank you, Dr. Qamar. Now let's turn to page 641 of the hearing bundle.
I have it.
Okay. Now this is the first application, and you accept that you signed it on the 9th of October.
19th of October.
Sorry, 19th
Sure.
of October 2018. Right.
Sure, I did.
And if we turn the page, there is a second application, and that's signed on the 28th of November 2018.
Correct.
Now, in terms of the reason why you signed 2 applications, do you accept that the second application was signed as the first one had the incorrect authorized application fee? Do you recall that?
What I recall is what had happened was, after I filled out the first application, one of the questions on the application was if I had a malpractice carrier, and I said yes. But when I spoke with the HR department of the Bermuda Medical Specialist Group, they said that you have said yes because you do have a malpractice carrier in United States, but you do not have one in Bermuda. And the question pertains to if you have malpractice in Bermuda. And so then I filled out another form in which I stated I did not have medical malpractice, because I was told that I could not have medical malpractice carrier unless I had registration with the Bermuda Medical Council. So I don't know why that question was there, since you cannot have malpractice carrier without having the registration. But 2 applications were filled out with that difference between the 2.
Well, I'll take you back to 641. Now I accept that the photocopy is not that clear. And I just wanted to be clear as to why we say a second one was signed. I hear what you're saying, but if you look at where it says application fee, right above the address on page 641,
Yes.
you might be able to see it. It's 101, I believe.
I see that.
Right, and then if you turn over the page again, you can vaguely see it says 645.
Correct.
All right, so we'll just go back to the fact that you signed the application on the 19th of October, 2018, right?
Correct.
Now at section 8,
Right.
section 8 of the document indicates that you have signed this, that the statements in the application are true to the
Correct.
best of your knowledge, information, and belief.
Correct.
And let's turn to the settlement at page 995.
I have it.
Okay. If we go to page 103,
103.
yeah, sorry, 1003, 1003.
Oh. I have it.
Right? You accept that you signed that document on the 10th of September,
Correct.
right? And you accept that this document states that you neither admit nor deny the allegations.
Correct. And if I may take a moment here, because Your Honor had asked this question as to how come I initially, with the DOJ and the OIG, settled, and I said that I deny all allegations. And then over here, I would say either I'm not denying or admitting. But I wanted to point out that the allegation in this case is not the allegation of a wrongdoing regarding doing unnecessary cases. The allegation is simply that I am not a provider of Medicare and Medicaid. So there's a huge distinction. So this statement, whether I'm not accepting or denying, is not related to the conduct which led to the exclusion. It is the mere fact that there has been an exclusion. And of course, I could not deny that.
Yes.
Thank you. And you also accept that in this document, it states that you admit that the facts alleged in the complaint, if proven, would constitute violations.
Sorry, Ms. Still Francois, can you repeat your question?
The question is, you admit that in the document, it states, you further accept that the document says, you admit that the facts alleged in the complaint, if proven, will constitute violations. Sorry for the way in which I
If
posed that
proven.
question. If proven.
Yes.
The fact, and that is true, and the fact alleged was that I was excluded from Medicare and Medicaid. And that was a fact.
Now you accept that 1 month before you completed the application form on the 19th of October, 2018, you agreed to the settlement. You signed the settlement.
Correct.
Now, do you accept that this settlement outlines the proposed disciplinary sanctions that would be taken against you?
Correct.
Right. So if we go to page 996, now under stipulated disposition,
Yes.
So the first one, the letter of concern. So the board shall issue a letter of concern against the respondent's license. Yep. The second one speaks to an administrative fine of $5,000. Yes.
Yes, I do.
Number 3 indicates that there was to be a reimbursement of costs.
Correct.
And I'll take you over the page to 998. And number 5 says there was to be continuing education.
Correct.
Right. So I'm going to take you to page 1004.
I have it.
Right. And you'll see under final disciplinary action. So pursuant to the final order, the following penalties were imposed. And what's there is exactly what I've just read out, correct?
Correct.
So let's go back to page 641, the application.
I have it.
Right. I'm going to go to question number 3.
Yes, ma'am.
You accept that question number 3 says, has any disciplinary action been taken against you by any medical authority?
Correct.
Yes. Question 3 does not speak to the sanctions or penalties imposed. You accept that?
I wholeheartedly believe that I answered it right, which was no, because no disciplinary action had been taken. The disciplinary action was entered into in February, and more importantly, it was a clear understanding with the Florida Department of Health and the Board of Medicine that they will allow me a few months to secure a waiver of exclusion. And if the waiver of exclusion was to be secured, then the entire document will become null and void.
But it's the case, you did not seek that waiver of exclusion, correct?
I
Sorry,
did.
you did not. Sorry, what was your question, Ms. Still Francois?
Did you seek that waiver of exclusion?
I did, wholeheartedly did. Not only did I seek that waiver of exclusion, 2 US Congressmen, Ted Yoho and Neil Dunn, 2 mayors, Ocala and Williston, a petition signed by 1,000 patients and a petition signed by 250 employees. And the OIG, the Office of Inspector General, invited me and my patients in an unprecedented move to come to Washington, D.C. and meet with them in person. So the waiver was indeed applied for. Unfortunately, it did not come in February when the final order was entered. And all of these disciplinary actions and the proceedings under the Sunshine Law were open to the public. They are posted actually on the website of the Florida Board of Medicine and the Department of Health. So it is not in any way concealed from anyone.
So you said that it didn't come through, but isn't it the case that you withdrew it?
No.
You did not withdraw it.
Absolutely did not withdraw it. I continued to seek a waiver of exclusion till the very end. The only issue was the Office of the Inspector General said that you only have a few months left in your exclusion period, and it would set a wrong precedent for them to allow a waiver to go through. It would be better for me to complete the term of my exclusion of 3 years especially because it is voluntary, especially because it is permissive, rather than seek a waiver. But initially, they had invited us to seek a waiver. In fact, Mr. Robert DeConti, who's the assistant OIG, the Inspector General of the HHS in USA, was the person who invited the application for the waiver of exclusion.
So that I just understand your answer correctly as it relates to question number 3. You accept that the penalties imposed were what was outlined in the settlement agreement, but you do not accept that your answer to question number 3 could have outlined the fact that you currently had signed the settlement agreement?
Signing a settlement agreement which has not been enforced, which will be possibly enforced a few months down the road. Quite honestly, if you look at the context of the question, I wholeheartedly believe that I answered the question correctly and truthfully. I also want to, I'm so sorry. I just wanted to make a quick point. I wanted to elaborate on what Sam Stevens said earlier. It was the first time I ever applied, of course, for an application seeking registration in Bermuda. I've had a license to practice medicine in Pakistan, one in Saudi Arabia, one with the Irish Medical Council, one in the state of Connecticut, and one in the state of Florida. And on every single occasion, I either had a telephone or an in-person interview after filling out a cursory form and providing the CV and my certificates. And I'm in no way criticizing the process in Bermuda, but quite honestly, I absolutely 100% thought in my mind that there was going to be a follow-up interview of sorts, either on the telephone or in person, which never happened. And in fact, if anything, if nothing comes out of my dilemma, and if the honorable court today says that, no, I cannot practice in Bermuda, I will plead to you to at least make one reform in the process. And that reform is, please communicate with the applicants and not with the employers. For months, I was under the impression that I was registered with the Bermuda Medical Council when I was not, because I had been given a number, a registration number. And not only that, many communications were made by me. I kept calling the Bermuda Medical Council office, and the staff kept telling me, we are not going to communicate with you, we'll communicate with your employer. I'm the person, if there is a source of information, it's me. And it's my livelihood and it's my license. And I can give you firsthand information, but for some strange reason, the process has to go through the employer. And because of that, there was months of delay where I had absolutely no clue what was the kind of information that the Bermuda Medical Council was looking for from me. And of course, my employers are busy people, and I'm not first on their list of priorities. I'm so sorry, I'm going on a tangent. My apologies, Your Honor.
Well, I mean, it's for you, Ms. Francois, too. This is your cross-examination. So, I mean, you can secure the answers to your questions, or if the witness is being difficult, and I don't think the witness is being difficult.
No, I don't believe that is being difficult.
So I mean, I'm just going to permit his speeches if you are content with them as in the context of your cross-examination.
Which, well, if it is the case that I do believe he's going on a tangent, but some
I mean,
of
you might think it assists you. So
and some of it assists me because yeah. I think what I understand what Dr. Qamar is saying is because he thought he was going to have an interview, he did not have to answer the questions in a fulsome manner at the outset. Is that what you're saying?
No, it's not that at all. I was saying that we all could have been saved a lot of heartache and time and money and court's time, actually, if there was just a better communication, that's all. And a direct communication with the applicant.
But what is the relevance of the interview? I'm trying to understand why the interview process would be relevant to your completion of the application.
I believe
No, I
it's
think his answer, sorry, I am going to cut in here, Ms. Francois. His answer is pretty clear. He is saying that he anticipated that there was an initial process of submitting an application form, which would be followed up by an interview, as was the case when he had applied to be registered in other jurisdictions. And so he felt that any further information that was needed would come in that second tier of the process. That's how I understood his question. I just don't want to belabor the point. I don't want to invite him to repeat answers. He said it, no, I would think maybe 2 or 3 times already.
Thank you, Your Honor. That's exactly what I meant.
Okay, I'm grateful. So what I'm going to put it to you that when you tick no to this question number 3, that was not a fulsome and honest answer. Do you accept that or do you not?
I would beg to disagree.
And that when you answered number 3 and tick no, that was not true to the best of your knowledge, information, and belief.
It was true to the best of my knowledge and belief.
Okay, let me move on to question number 4. And let's read question number 4. Have you had privileges denied, revoked, or restricted in a hospital or other healthcare facility? Yes? You tick no to this question.
Correct.
Right. So let's go to page 792.
I have it.
Right. And just under your name, sorry, just under Dear Asad Qamar, MD.
Correct.
Right. It says your Medicaid privileges are being revoked effective May 2018, 2005.
Correct.
Yes. And I accept, I believe you appealed and it was actually implemented in 2017.
Correct.
But that date is before you signed the application form.
Correct.
Right. So how do you...
Ms.
The application-
Francois, you said it was appealed and implemented in 2017?
Yes.
Appealed.
I believe he appealed it,
Mhm.
and the final implementation of what was outlined in the letter was in 2017.
Okay.
Actually, the
And are
revocation.
you looking at the application form now of 2018?
Yes.
Okay.
So
I
I'm suggesting that the letter that you received, which speaks about revocation of privileges, was prior to you signing the application form.
That is correct. I just want to point out that the revocation actually was never finalized because it went to an appeal process and then it was discharged because a settlement had occurred. So actually a formal revocation never occurred, but that's a moot point. Coming to your question, yes, it is true that I had been revoked by Medicare when I filled in the application form and I said no to question number 4. That is indeed true.
So would you accept, therefore, that that was not a fulsome answer when you tick no?
It's honestly shocking to me that Medicare, which is an insurance, is being viewed as a facility, which would be a hospital or an academic center. If you ask 10 physicians, I would bet that 10 out of 10 would answer no to that question, because being not on an insurance panel has nothing to do with having your privileges denied at a facility. I think it was an absolutely 100% truthful answer. If that question said, if an insurance has ever denied you, and I said no, I certainly would have lied.
Yes.
But the fact that you had privileges denied, don't you think that it would have been relevant to at least notify the committee of that?
Ms. Schick, I'm sorry. What is your last name?
Dill Francois.
Oh, Ms. Del Francois. I have filled hundreds of applications during these 20, 30 years of my professional career regarding insurances, regarding facilities. And in all honesty, there is always a separate question regarding privileges in a hospital or in a medical center versus having any insurances denied. Therefore, it did not occur to me for a second. And quite honestly, if I ever came across this application again, perhaps it would have never occurred to me to say yes. However, now, of course, the dilemma that we find ourselves in, it's hard to extrapolate one to the other. At that time when I filled the application form, yes, to the best of my ability, I answered that question in a fulsome, wholesome, truthful way.
Dr. Kumar, isn't it the case that you asked Dr. Bazin for advice on how to complete the form? This is what you say.
I did.
Okay. If the questions were so straightforward, why did you need advice on how to complete it?
The reason simply is because, and I'm glad, actually grateful that you brought up this point. When I first met Dr. Basden and I met the CEO, Mariko of the BMSG, in the very, very first meeting or interview, and that is where we can look at how important an interview can be, I fully disclosed to them the entire legal history, although they had no knowledge of it and they had not asked me about it. And the only reason I asked Dr. Basden about filling out this application form was because I told her, I said, I have in great detail discussed with you what has happened. And although I have not been found guilty of any wrongdoing, what do you think is the best answer? And I very, very, very clearly remember it was not the question 4, but it was the question 3. And she said, and I gave her the context of the waiver process and the application for the waiver process and the fact that the order had not been entered and will not be entered because the Florida Department of Health and the Board of Medicine were actually helping us and cooperating with us. She said clearly the answer is no to it. She agreed with me. I'm not in any way putting it on her shoulders, but, and it just made me feel comfortable. And I thought that is exactly what I was thinking. I would not for a second say that I was going to mark it as yes, but she said it no. I was already thinking that the answer is no, and she agreed with me.
Okay. You accept that we don't have anything from Dr. Bazin to suggest that that's what occurred?
Correct.
I'm going to suggest to you that the reason why you asked for assistance is because you were unsure as to how to answer that question because you had these matters pending.
I beg to differ, but certainly you're entitled to your opinion.
Now, your application form, you didn't submit any of the documentation of your application form. You accept that, right?
You didn't submit any
of this documentation.
Okay.
With this application.
Not saying any documentation at all. You're saying
no, any of this
particular. Okay.
That we're discussing, because I know
Right.
that you did provide your qualifications.
I did provide my qualifications, my certificates, and my CV, yes, but nothing regarding the matters we are discussing now.
Right, so you accept that you only submitted positive information about yourself?
I would say information, not necessarily positive information, but information that I thought was relevant to the application at the time when I filled out the application. But again, like I said, I was under the impression that there was going to be definitely a follow-up. In fact, I was shocked when I found out that I did have the registration number.
Okay, so you accept that you were asked by the committee for additional information?
I was, unfortunately, when I found out about it, it was months after the council had asked for the information. And because I was unable to, the only reason Sam is here, I respect him and like him dearly, is only because I was unable to have any direct communication with the council. Therefore, I had no choice but to involve someone as an intermediary.
So are you suggesting that's the reason you took 4 months to respond?
Absolutely.
Now, by the time that you responded to the committee, do you accept that they had the majority of the information about you in any event by that time?
I have no idea. I have no clue what they had or they didn't.
Isn't it the case that the committee was asking you questions about these matters?
Right, they did. But again, it is impossible to know what they had and what they didn't have. But whatever we possibly could have collected, we provided to them.
And that generated a number of large binders. You accept there was a lot of information?
Yes.
And do you accept that that amount of information that was provided after the application was submitted may be a cause of concern for the committee?
I honestly believe that it shouldn't be. And the reason I say that is because it is surprising and amusing and shocking that Google searches were done, but only negative information was found. Unfortunately, for some reason, the BMC never stumbled upon, other than sensational articles, they did not stumble upon hundreds of ads, hundreds of letters by my patients, which are on the websites, and the letters from the staff supporting me, and hundreds of reviews on vitals and health grades, which are 5-star and praise me. But for some reason, nobody stumbled upon them, but they only stumble upon small, local, and other sensational news media.
But Dr. Qamar, isn't it the case that Dr. Ross, in the judgment, indicated that there was some positive things about you? I'm just looking for the reference for you.
In all honesty, although it might seem that I'm here because of my ego or just because I'm mad at the BMC or something like that, I appreciate what you're doing. You're doing your job. I appreciate Dr. Peakball. I appreciate Dr. Ross. They've done whatever they could do best in their positions and with their convictions. And I appreciate whatever positive they have said about me. It is nothing personal.
But my question is, I know you said that they've looked for all of the negative information, but isn't it the case that they did accept that there was some positive qualities to you? Do you accept that?
I do accept. It's just that the percentage of the positive was a little bit on the lower side, but I'll take that. I appreciate it.
Can I ask you, why does Medicare have copays for medical procedures?
I'm sorry, what is the question?
The question is, are you able to advise why Medicare has copays for medical procedures? How does that work?
Well, Medicare has copays because one, if Medicare pays 100%, the system will break, basically. Now, the second reason is because they want to make the patients responsible for their health care. And I know what you want to ask, so I'll wait till you ask your question.
Okay. And isn't it the case that you waived the copays?
I did.
Okay.
In a significant number of patients. Patients who were unable to pay their leases, who were unable to pay their mortgages, who were unable to pay for their oxygen, who were unable to pay for their taxi cabs. I did that. The Medicare allows it. Every single thing was documented. Out of the 24,000 patients, 3,000 patients had their copay waived. The average copay waived was $13.50. Hardly an amount that will induce a patient to have an invasive procedure done on them. But yes, I did waive them, and I'm proud of it because that was the humanitarian thing to do. That was the right thing to do.
So you waive them, but our suggestion is that it's an incentive for patients to undergo unnecessary procedures.
$13.50, ma'am. I don't think I would ever have a heart cath done, or any patient would have a heart cath done for $13.50. But those $13.50 can mean life and death, a couple of meals, 2 cab rides. And Medicare allows for it. The documentation was there. In fact, when we met for the settlement, the OIG and the DOJ said that we will take away the copay issue off the table, and we'll take away the unnecessary procedures off the table, and we'll change the unnecessary procedures to poorly documented procedures so that you feel comfortable in making the settlement. It was all about, from very first day, about dollars and cents. It was simply a financial transaction for the government.
Okay, so you don't accept that it causes overutilization.
I certainly don't, because the government looked at 32 service lines. They intervened on one, peripheral vascular interventions, and they looked at 1,831 films and took 4 films and said these were unnecessary. That makes less than 1%. And even those 4 cases were challenged by 2 nationally known experts, both of which are not known to me and both of which were not paid experts. Dr. Gino Cedillo and Dr. Michelle De Gregorio.
Okay, thank you, Dr. Qamar. Now I want to take you to page 384.
I have it.
Okay. Now, your attorney spoke about the fact that there was no probable cause found.
Right.
If we look at the second paragraph, so right, in any disciplinary case for which probable cause is not found, right? Now, look above where it says, "Dear Mr. Mabry." There's a case number right there, correct?
Yes.
Right. So this letter is in relation to case 2017-18262.
Correct.
Right. So now I'll take you to, so I'm just looking for my next page. It was said that this was not mentioned or no credit was given for this. So let me take you to page 710. This is the judgment of the BMC.
I have it.
Right. So you see at paragraph 44.
I do.
Right. And you accept that the committee does mention that there was no probable cause found in that particular case.
Correct. And I think Sam said that he did give credit where it was due. He just mentioned, I think, if I'm not mistaken, that more recently in the submissions it was not mentioned, but he did say that it was mentioned early on. But I appreciate it.
I don't believe that he did, but in any event, we've accepted that at paragraph 44, you were given credit for it. Right. So I'll take you over.
I'm sorry.
I'll take you over to paragraph 48, but at the end of that paragraph, so on page 711.
Right.
And you see that that paragraph relates to a different case number, 2015-20338.
Right.
Right. So it is the case that the probable cause was only in relation to that particular matter and not this one.
I'm sorry, I didn't understand what you were saying.
So your attorney had indicated that no probable cause was found for all of the matters. And I'm suggesting to you that that is incorrect. It was only in relation to one of the cases. The case at the top of 711 is not mentioned in that letter.
It was in relation to the case of the DOJ and the OIG against me, the main case, the QTAM or the whistleblower lawsuit case of unnecessary procedures and waiving copays.
Right, but the question is, you accept that not all of the cases were mentioned in that letter, because the suggestion was that no probable cause was found for anything. And what I'm trying to suggest is that this case number does not appear in the letter that was put before us.
Ms. Del Francois, I don't think that Sam ever said that. He's my attorney, I'm not his attorney, but I think he mentioned that this, in particular to this case, that the DOJ and the OIG brought the QTAM, but he didn't mention a blanket thing. In other words, of course, as we discussed, they sanctioned me for not having Medicare and Medicaid, and I paid the fine, as we just discussed. But go ahead, please.
Well, the only reason why I'm saying this is because what was suggested is that you were completely exonerated. And I just want to put before the court that those were two different matters. And
I was completely exonerated in the case alleging unnecessary medical procedures and kickbacks to patients. I was completely exonerated in that.
Right, so it was limited to that case.
Yeah.
Grateful to you confirming that. And can I confirm, is it the case that you were never found guilty of malpractice?
Never.
Sorry, craving indulgence. Now, the suggestion was put to us that we can only proceed on proven facts in relation to your good character, whether or not there's good character. Now, I'm going to put to you what we say is a number of proven facts that were evidence in the documents that were placed before the committee. Okay. Now, isn't it a proven fact that in 2011 and 2014, that you and your business were sued under the whistleblower provisions of the False Claims Act?
It's true.
Right. And in 2 civil whistleblower lawsuits by a former employee, Robert Green, and by a third-party accountant, Holly Taylor, who had previously worked for a medical management company that oversaw your management and billing.
Correct.
Okay. And it's a fact that on the 22nd of December, 2014, the U.S. federal government saw fit to intervene in both of these cases on the 9th of April, 2015.
Correct.
And they've consolidated, correct?
Correct.
And it's a fact that you and your business elected to settle the case in 2016 for millions of dollars in a settlement of allegations that you encourage patients to consent to thousands of unnecessary medical procedures, routinely without charging the required Medicare copayment, thereby allegedly defrauding Medicare and making millions of dollars in the process, and allegedly putting patient safety at risk by not making medical decisions focused on patients' needs, and that you settled the lawsuits despite earlier claims that you would fight the allegations. Now, I have those at the hearing bundle, page 841 to 843, and pages 881 to 886. So you accept that what I read to you just now is proven fact. I can break up the question if you'd like me to.
Oh,
It is-
yes, I don't know what your question was out of that, Mr. Francois. I want to be careful before you put it to him as a question. Are you
Yeah,
just,
I can break
just
it
putting
up.
it to him that he entered into a settlement where the allegations arising were as you described them?
Yes,
Okay. Well, we know that.
right. Well, my lady, what I'm trying to do is that his counsel had indicated that we didn't have any proven facts. So I'm trying to outline each of them so that it's clear that we actually do. So I accept that he has spoken to some of the allegations. What I'm trying to do is just put them in chronological order and have him accept that, yes.
If you're
These-
listing out what are proven facts, I think that you should be very succinct in your suggestions to the witness so that his answers are clearly in answer to whatever the proven fact is you say he should accept.
Okay, so I'll go back to that question, Dr. Qamar. Isn't it a proven fact that you and your business elected to settle the case in 2016 for millions of dollars in the settlement of allegations that you encourage these patients to do unnecessary medical procedures?
Yes, we settled the matter for these allegations. Yes.
And isn't it a fact that you settled the lawsuits despite the claim that you would fight the allegations?
It is.
Despite
Despite the claim that he would fight the allegations. You answered yes already, right?
I answered yes. I wanted to put it in context, but I don't know if the court has the time to. I just want to point out that yes, eventually there was a settlement, but as you pointed out, in 2014, I was asked to pay a significant amount of money and to settle the matter. And I was told that if I settled the matter, then there would be no press release and I would continue to practice and I would not be excluded. And I declined. And then in early 2015, I was a payment suspension from Medicare was made, and I was again contacted by the DOJ, and I was asked if I had come to my senses, and I said I will fight it. Then I was revoked from Medicare. I continued to fight. Then I was revoked from Medicaid. I continued to fight. And then eventually, when I had exhausted all of my personal financial resources, I had no choice but to declare bankruptcy. And through the bankruptcy, a settlement was made. Whether it was me, whether it was any other human being on planet Earth, the bottom line is the Department of Justice is the United States department, which the government prints the money and has its army. Nobody can fight them. I had to make a settlement. I just wanted to put it in the context. It's easy to say that I initially said I'll fight it and then I settled it. I didn't settle it because I was guilty. I settled it because I had no choice.
Okay, thank you, Dr. Qamar. Next, you accept it's a fact that in May and June 2015, that the Center for Medicare and Medicaid, which you know is the federal agency that oversees Medicare, they banned, suspended you and ICE's Medicare reimbursement payments,
Correct.
and it terminated you involuntarily from all federal Medicare programs,
Correct.
right? That your voluntary exclusion came subsequent to that.
Correct.
And it's a fact that on the 12th of June, 2015, the OIG for Florida, the Medicaid Program Integrity Office, wrote to you informing you of your involuntary termination from Medicaid as a result of your termination from Medicare. Correct?
Correct.
And you admit that this was a 20-year ban. It was a 20-year ban.
Which
Can you
was
repeat that?
subsequently decreased to 3 years.
Which was
Yes.
subsequently decreased.
If I may point out that the Medicare exclusion was supposed to be 18 years, which was decreased to 3 years. And the payment to the federal government was supposed to be $110 million, which was decreased to $2 million. The point I'm trying to make is that there was a lot of fighting and then a settlement, not just a settlement right away.
Okay. It's a fact, Dr. Kumar, that in 2015 and released again and updated in June 30th, 2016, that the U.S. Federal Department of Justice of Public Affairs issued a press release to the world at large to say that you had settled the 4 cases for $7.3 million.
Correct.
And it's a fact by the terms of the 30th of June 2016 settlement that you agreed to be banned for 3 years from providing care to Medicare patients, which this was over 80% of your practice,
Correct.
right? And you additionally agreed to be excluded from all other federal health care programs.
Correct.
And you agreed to be listed on the Office of the Inspector General's list of individuals excluded from federal health care programs.
Correct.
Now, it's a fact that on the 26th of July, 2017, you signed a settlement agreement with the Agency for Healthcare Administration to terminate your participation with the Florida Medicare program, beginning on the 1st of February, 2017 to the 1st of February, 2020.
Florida Medicaid program.
Yes, sorry, Medicaid.
It's okay. Yes, that's true.
Okay. And it's a fact that on the 24th of October, 2017, Prosecution Service Department of the Florida DOH brought an administrative complaint against you based on the fact that on or about the 28th of May, 2015, the government had involuntarily terminated you from participation in the Medicare program.
Correct.
And that on or about the 12th of June, 2015, you were involuntarily excluded from participation in the Florida Medicaid program, and that Florida law subjects any person to discipline for being terminated from the state's program, from Medicare program, unless your eligibility is restored.
Correct.
And it's a fact that on the 3rd of January, 2018, under the subheading Current Medical Staff Privileges, that your attorney, Mr. Tracy Mabry, wrote to the Florida Department of Health in response to their investigation that you had inactive medical staff privileges at the I think it's Oakland Regional Medical Center. I'm not sure how to pronounce it.
There are two hospitals in the area. In one hospital, which is Monroe Regional, which is now Advent, several years ago, way before any of these investigations, I had voluntarily made my privileges inactive because I was too busy in the outpatient work. And in the second hospital, I had again filed an application to make my privileges inactive when I was unable to give time to in-hospital patients. There was no termination of my privileges by the hospitals. If that was the case, then they would have reported it to the National Practitioner Data Bank, which is a reportable event if you lose your hospital privileges. In both cases, I had voluntarily made my privileges inactive.
But just to confirm, the inactive medical privileges was a result of, this was pending your reinstatement of federal health care program participation?
No, they can be reactivated at any time. The reason I made them inactive was because I don't have to go through the entire application process. But I don't intend to, because quite honestly, at age 56, you want your younger partners to take night call. And if you have hospital privileges, then you're stuck with night call in the hospital. So having privileges is a double-edged sword.
Is it the case that some of your patients weren't able to fill their prescriptions written by you?
Correct.
As a result of this?
When you have a patient who has Part D Medicare, and the Medicare pays for the medication, when you're excluded, even when I was volunteering my services to my Medicare patients, they were unable to get their prescriptions filled if I wrote for them, but they could get them filled if one of my associates wrote for them.
Now, the case that I spoke about earlier that was not mentioned in the letter which spoke to the no finding of probable cause. So do you accept that that case that on February 8th, 2019, that particular case came before the DOH Board of Medicine for the purpose of considering the settlement agreement number 2?
Correct.
And that 6 days later, on the 14th of February, 2019, the CMO, so Chief Medical Officer of the Bermuda Medical Council, this is Dr. Peekball, met with your prospective employer and Dr. Arlene Baisden of BSMG, and verbally and in writing later that day asked about the status of the DOJ's case against you, as well as the confirmation that you were still in good standing to practice cardiology?
I have no personal knowledge of that meeting. I have seen a document referring to that. Quite honestly, I'm not privy to any of the communications between the BMSG and the BMC.
You said you're not privy to any of the communications.
Any of the communications.
Right, but what's your status with the BMSG now in terms of, you said that you're not familiar with any communications, but they're your future employers.
Correct. I'm referring to when the early 2019 part that you were mentioning. And that's what I meant when I said, I wish there were direct communications. So things were relayed by the BMC to the BMSG, and then from the BMSG to me, and then I would talk to BMSG, and BMSG would talk to BMC. I have a very good relationship with them. They are waiting wholeheartedly for the outcome of this case. And they certainly want to utilize my services.
And it is the case that on the 28th of February, 2019, you had the disciplinary penalties imposed against you.
Correct.
Now, I know you said you have no communications with regards to the MSG, but isn't it the case that neither you nor them, informed the Bermuda Medical Council, who had posed the inquiries only days before, and despite the fact that your application was still pending?
I did not know about the inquiry by the BMC till much later. It was a few months later. It was when I contacted Sam's firm, asking them to help me with the communications with the BMC.
Now, you accept that on the 21st of March, 2019, you paid a fine and cost to the total sum of $7,799.52.
Correct.
And you accept that in a letter dated the 6th of June, 2019, from your attorney, Tracy Mabry, you confirmed that your participating status had not been restored because you abandoned such efforts just before you appeared before the board when the September 2018 settlement number 2 in lieu of a formal hearing was entered.
Abandoned the, I'm sorry, I didn't quite get that.
So I'll read it again. In a letter dated the 6th of June, 2019 from your attorney, confirmed that your participating status had not been restored.
Had not been
restored.
Mhm.
Because you abandoned such efforts just before you appeared before the board when the September 2018 settlement agreement in lieu of a formal hearing was entered.
My lady, I'm very reticent to interject in a cross-examination, but I think as a matter of procedural fairness, if the Respondents' Counsel is going to be putting contents of a document to the witness,
the document should be shown.
To show it to him so he knows what's being discussed and what's being put to him.
Mm-hmm.
Sorry, 1 minute. Sorry, crave your indulgence, my lady.
Yeah.
I'll move on from that question for now. We just find the proper reference.
I have been considering a very short restroom break. It's now 7 minutes past 4. I'm hesitant only because I have not seen any success with just simply putting me into a breakout room and then resuming. It seems that the call would have to restart, and by the time that happens, it will be the end of the court date. How much longer do you think you will be in cross-examination altogether, Ms. Stokely?
I won't be that much longer, but I'm also cognizant of the time, but I just wanted to inquire from the court, is the intention to continue on today, or will we be breaking to tomorrow morning once I've completed this aspect? Just so I
Once you
understand.
finish your cross-examination?
Yes.
Well, once you've finished your cross-examination, I would have been expecting submissions.
Okay.
And those submissions would have followed tomorrow morning, was the time frame. But I'm trying to get a sense from you. Are you likely to finish your cross-examination by 4:30?
I would think so. Yes, my lady. I would think that it's probably about maybe 10 more minutes or so.
Okay, then I think I'll let you finish to completion. If we can aim to finish up by 4:30, that would be helpful. Otherwise, we could break now and resume in the morning if you're going to be much longer than that.
I hesitate because I don't want to take up much more of the court's time, but it may be the best option to break now and then proceed in the morning. That's just so that
I didn't want to tempt you into the alternative. I would prefer if we finished this afternoon. Here's the reality, Mr. Stevens. Is it likely? Well, I can actually directly, Dr. Qamar, are you going to be joining us for the remainder of the hearing tomorrow for closing submissions?
I'm so glad you asked me, Your Honor. I would love to. Selfishly, I was hoping that my cross-examination will end today,
Okay.
but I can certainly change my schedule tomorrow. I'm so indebted to you for giving me the time. I didn't have to come to Bermuda in person, so I'm not going to ask for it. Whatever the court decides, I'm at your disposal.
Okay, thank you. Ms. Francois, I'm going to risk the technical complexities of a 5-minute break. And then we can resume, and I then would encourage you to go through to completion. If that takes us moderately over 4:30, then I think you will be forgiven, certainly by me, with the hope that we wouldn't go beyond 4:45 for me to time, obviously.
I'm grateful, man.
Okay. It seems to me that I will have to leave the meeting and we will re-sign in. Can I just encourage everyone to make sure that your computer screens are not facing any position which may embarrass you, only because we are live streaming, and I happened to review over the lunch hour some of the footage and noticed that during a break, the computer screen was on for one of the parties or one of the persons appearing without them seeming to be aware. So I would suggest that you be cognizant at that point. It was not you, Ms. Francois.
Okay, thank you.
Okay, so I'm gonna leave the meeting. I think the rest of you may be forced to do so. Let me just see from Ms. Aswood. Ms. Aswood, is it possible to place me into a breakout room, or are we gonna have to?
Yes.
Yes?
A waiting room, yes.
Okay, let's try that, and then we can keep everyone on the call, but just simply turn their cameras off. It's now on my clock 4:12 p.m. I would suggest that we resume at 4:20 p.m.
Okay.
Okay?
Okay.
All right, thank you.
Thank you.
Okay, so do we have everyone return? Mr. Francois, you are on mute,
Thank
which
you.
means that you can hear me.
Yes, I can. Thank you.
All right. And we have Dr. Qamar.
Yes, Your Honor.
Yes. Okay, thank you.
All right, Dr. Kumar, just start where I left off. So it's a fact that as to your soundness, it is undisputed and therefore proven fact that on the 20th of April 2016, you and your wife filed for Chapter 11 personal bankruptcy in the United States Bankruptcy Court of the Middle District of Florida, and that you also filed for bankruptcy on behalf of your business, Ice Fooding.
Correct.
And it's a fact that at the time that you and your wife filed for bankruptcy, that you had liabilities estimated between $10 million and $50 million,
Correct.
and that your creditors included the Medicaid Fraud Control Unit of Florida, and you also owed $237,901 in unpaid real estate and tangible taxes for 2015.
I honestly don't remember, but if it's written over there, I'm sure it's correct.
I can take you to the binder.
What I'm trying to say is I don't remember the exact amount, but I'm sure whatever the document indicates should be correct.
I see. So I want to take you back to the earlier question that I had asked about Tracy Mealy. Sorry, I'll just proceed. Now, isn't it a proven fact that a financial state of bankruptcy of a doctor poses a higher risk of profit-driven medical decisions, which is not in the best interest of patients or the healthcare system? Where the doctor can...
Ms. Del Francois, I think you should move on from that question.
Okay, I'm grateful. And it's the case that you remain in undischarged bankruptcy to this day.
Correct. But may I point out that basically the order for ICE's bankruptcy was entered into, and it was administratively closed and then closed by the court. As far as our personal bankruptcy is concerned, it has been administratively closed, and there is a very small amount of money. I believe it's to the tune of $20,000 to $25,000. But we were advised by the attorney not to close it and take full advantage of the time period of 5 years, simply because his thought was that there may be some unsecured creditors out there. It is in no way intended to defraud anyone. And just want to point out that every single secured and unsecured creditor has been paid. So the idea of being driven by profit would not apply in this circumstance.
And Dr. Kumar, all of the facts that you just admitted, you accept
Sorry,
that.
Ms. Del Francois, I'm sorry. I just want to give you some insight as to why actually we move on from the question. If you want to put it to Dr. Qamar that he was driven by the financial gain that he stood to obtain by coming to Bermuda, that's fine. But to put it generically, I think is just an improper phraseology. So it's completely open to you if you want to say that he was driven because of his own financial position. By all means, you can ask him that if you want to.
Well, yes, my lady. That's pretty much the inference. So the question is, Dr. Kumar, based on all of what we put before you in terms of bankruptcy and the funds owed, isn't it the case that you'd prefer to come to Bermuda, or you wish to come to Bermuda because you stand to gain a particular profit from coming here? A large profit, sorry.
It is totally incorrect. And the reason is, even during this time period, before my Medicare was restored and before my license became clear and active again, the monies that I was able to generate from my consulting work were more than the money that I will be earning in Bermuda, certainly. So I think to say that I was driven by that would be absolutely incorrect. And it certainly does not apply now either, when I have a restoration of Medicare as well as my licensure to clear an active status. In fact, I'll be more than happy to share with the court my current contract, which will make it very clear that I'm making actually a financially disadvantageous decision.
Well, you accept that we don't have anything before us which speaks to, at least not in this evidence, which speaks to the money that you say that you currently make, which is double.
Yeah.
I believe you said double for what you'll be making here.
I'll be happy to forward a contract to Sam no later than this evening, and he can submit it to the court in the morning.
But Dr. Qamar, my question to you is, you've sworn an affidavit for this court, you've provided all of your evidence, and that fact that you stand to be disadvantaged by coming to Bermuda in terms of the funds that you intend to make, you accept that that doesn't appear anywhere in the evidence that you currently have before?
I don't say disadvantage.
My lady, I have to object to this line of questioning. The reason it does not appear in Dr. Qamar's evidence is this is the first time in the entirety of this appeal that the respondent has raised this as an accusation. Now, if this had been put to him in a previous question, or if this had been made an issue prior to this appeal, then no doubt Dr. Qamar would have dealt with this in his evidence. But it's entirely unfair and inappropriate for a question to be put to him in cross-examination, which has never been put to him before, and then criticize him for not dealing with it in his evidence. That cannot be a procedurally appropriate way to proceed.
Well, I would respond by saying Dr. Qamar has indicated that he stands to be disadvantaged by coming to Bermuda. So I was simply following on from that line in response to.
Well, I mean, it stems from his earlier statement that he earns twice as much on his contract in the U.S. than he would stand to gain in Bermuda. And that was an answer to your question earlier in cross-examination, where you directed him to the substantial profits that he would gain for working 3 times a month. Yeah. So he's responded to a question that you've raised in cross-examination. As I understand it from Mr. Stevens' objection is that it does not appear to be an issue on the evidence that's been filed or in any of the skeleton arguments that have been filed with the court. And so if you're now going to challenge him, number one, as to why he didn't raise it earlier, Mrs. Stevens is objecting to say that's unfair because it did not appear to be an issue of dispute or an issue for to be addressed in the earlier stages when evidence was being filed. But if you are going to, in your cross-examination, challenge whether or not that's in fact true, I will obviously allow Dr. Qamar, as he suggested, that he's in a position to do, to adduce any evidence to address what you're raising now in cross-examination. It would be difficult for me to envisage how that could be fairly refused.
My lady, I'm grateful.
Ms. Del Francois, I just wanted to make a point. I didn't want my answer to be misconstrued.
Sorry,
as-
Dr. Qamar, 1 moment, please. I've just addressed counsel. Let me just see if
Sorry.
counsel wants to respond any further.
Sorry, I'm just trying to consider whether or not. So I hear what the court is saying, and yes, I'd like to invite the court to accept, well, to allow me to review Dr. Kumar's, the contract that he's referring to.
If it's, I mean, Dr. Qamar has indicated that he would be prepared to put this evidence before the court. I would question its real relevance to the question of his character, but if Dr. Qamar is prepared to provide that evidence, then we will, of course, provide it, and the court can make of it what it wishes to do.
Yes, I mean, I gave Ms. Del Francois some latitude in the earlier part of her cross-examination. It was not immediately clear to me what the relevance was about the financial gain that he stood by coming to Bermuda and so forth. But to be fair to Ms. Del Francois, she's not addressed me in submissions, as you have fully in your opening submission. And so I'm minded to give her a lot more, I think, free ranging rope to engage in this type of course examination.
My lady, that's fine. I was just making the point, as I think the court has the point, that a question was being put to him, and the witness was being criticized for not having dealt with it in his evidence when it has never been raised previously.
Mm-hmm.
I'm grateful. I understand counsel's submission to the court. As I indicated, it was on the basis of the dishonest answers that were put on the application. So if it is the case that, you know, he's invited to provide the evidence, then I accept. I'd like to view it.
I mean, I'm not going to require him to do it, but if he wants to file it, then he won't be stopped from putting that in. I think that's unfair.
Yes, I'm grateful. I accept that he's not being forced to, but I guess my question is, if the court is minded to allow him, then yes, I will view the actual document.
Mm-hmm.
Okay. Now, Dr. Qamar, you've accepted the admitted facts, the proven facts that you have accepted.
Right.
You agree that you did not advise the counsel of this when you submitted the application. You agree with that?
You mean the BMC?
Sorry, yes, the
Yes.
BMC committee.
Yes.
So I'll just take you to page 642, and this is the application form.
$642.
Yes.
Okay. I have it.
Right. And you accept that at the top of 642, in the second sentence, in the third sentence, it provides that if more space is needed to fully answer questions, attach additional sheets with typed responses.
Correct.
Right. And I'm going to put it to you that it would not have been difficult to simply add those additional sheets with the additional information.
I would submit to the court that it would have been almost impossible. First of all, the questions were answered truthfully. And secondly, it has been months and we have 1,020 something papers and we are still debating the facts. I don't know how possibly I could have provided to the council everything that we have in front of us today with that application. That just would have been impossible.
But you accept that you provide nothing except your qualification.
Correct. I provided my qualifications and I truthfully answered the questions. And I did expect a follow-up, which unfortunately did not happen or happened after several months.
And my lady, that concludes the cross-examination.
Thank you. Mr. Stevens, are you going to be re-examining Dr.
No.
Qamar?
No, we have nothing further.
Okay, thank you. So Dr. Qamar, that now brings a close to your evidence. Thank you very much for it. You are free to join us when we resume tomorrow or not, but your evidence is done. So any other participation you have will just be in an observation capacity, okay?
Your Honor, may I take 30 seconds before we end today? All I want to say is that when I made the statement that it would be disadvantageous to me, I did not in any way mean disadvantageous. I wasn't focusing on the financial aspects. I want to say that it is going to be advantageous for me because it is incredible professionally for me to be able to create something or a service where there is none. And I think that will truly be a legacy. It is something that I will cherish forever. I don't have a whole lot of working years left, maybe another 10, 15, God knows how many. And when you create something new in your field, in your profession, you look at the legacy and you see how it has helped people and how it has changed or shaped an environment, a community. So I didn't mean for it to come across as someone pouting about the disadvantage of taking a financial cut. It actually is going to be extraordinarily rewarding for me personally and professionally. Thank you.
Okay, thank you. So I don't know if any questions arise out of that final statement. I think I should give counsel the opportunity if you so
No, my lady,
desire.
I believe that Dr. Qamar has put that forth for a reason. I'll address that in submissions.
Okay,
He's
thank you.
clarified whether or not it's advantageous, so I can put that in submissions.
Okay, thank you. Mrs. Stevens, I would expect you have no questions to ask out of that.
No.
All right, so we can adjourn for the day. Any other evidence will be the witness statements that we've referred to, and you can address me in closing submissions as to how I should treat all of those witness statements where the witnesses were not cross-examined. Am I correct in that approach?
That's right, my lady. I'll be making very brief submissions in relation to the the balance of the respondents' witness statements.
Mm-hmm. Okay. Well, then we shall resume at 9:30 a.m. tomorrow morning. Yes?
Yes, I'm grateful. I'm
Okay,
grateful.
thank you very much. All right,
Thank
the matter
you.
is adjourned.
Thank you very much.
Okay.